Making a criminal. Disc number 5. A reality flick series. Starring very important people. Very important. Big shots. Making a criminal. A reality flick series. Millions of taxpayer dollars. Disc number 5. Reality ahead.
Warning.
All roads eventually lead to reality, Boulevard. Detour in any direction, to the delusion all trolley.
Can't wait till you end up in prison.
This commercial break is sponsored by the Maryland Departments of Ongoing Authorized Crimes. Although they are the sponsors, it's being paid for by the taxpayers. Alex's final journal entries. The month before, Miss Siliski had her 9-year-old daughter steal Alex's audio journal recorder. Maya reported having done so out of fear of her mother, after watching Alex being beaten up many times, and witnessed more beatings just days before. Miss Siliski told the police, who noted in the report the theft was her 9-year-old daughter's idea. Tossed Maya under the bus to protect herself. See October the 5th, 2011, police report. Mr. Stengel and the kids went to a family bar mitzvah in the Philadelphia area. For keepsake, using his phone, Alex took lots of photos and video at the party. He later recorded some entries, which turned out to be his final entries.
It's court order, as you would say. It's court order. It's court order. Give this to your lawyer, like you always do. It's an invasion of privacy. Stop invading my privacy. Stop deleting my stupid recordings. What do you care? Stop deleting my stupid recordings. What do you care?
One day or so later, Miss Siliski washed Alex's phone with his clothes. Apparently, it's hard to tell if a large smartphone is sticking out of an 11-year-old's small pants pocket. Ms. Siliski made it very clear it was Alex's fault. The evil goal: destroy any evidence of journal entries and of any other family. They all swear under oath to having reviewed all of the evidence and given each occurrence its proper weight. Therefore, they collectively agree everything shown so far, and all that is to come, just doesn't carry that much weight in the decision-making process, either individual actions or collective, and whether decided by a paid individual person or expert, or them all collectively. A bit odd, given, for people that give the evidence no weight, they sure go to great lengths to destroy whatever evidence they possibly can, even refusing to return all the stolen evidence, or demand the return of all the stolen evidence. Also peculiar is, they all collectively apply their weight of evidence to the same virtual non-existent, manufactured frauds and abuses.
When I see your lawyer, I could sit here all day. Just show this to your lawyer. I don't care. It's court order, as you would say. It's court order. It's court order.
Miss Siliski just left out the part regarding how the court orders were obtained. False filings, false testimony, fraud, layered with fraud, then sprinkled with fraud.
How much is just one memory worth? How much is just one missed memory worth?
Welcome to the Bradford G.Y. Carney's Introduction to Fraud Billing and Counterfeit Orders, Scams, from the law firm Royston, Mueller, McLean & Reed, LLP. Working development research stage. Agreement. Pause to read. Minimum age of 18 required. Fraud. Child predators. Corruption. Racketeering. Child abuses. Collusion. Psychological warfare. Waged. On children, schools and the public. And on and on. No way out. Legally or ethically.
Ever. You don't even let me, because that's what it feels like. So you talk, I do the shooting. Mark! No!
I'm kind of screwed in this way because he hasn't physically hurt me. I'm kind of screwed in this way because he hasn't physically hurt me.
Justice. A judge abides by facts, laws, truths and evidence. A justice creates their own facts, laws and truths, in the face of opposing evidence, and, or knowingly applies, lies to law. When the scales of justice become the scales of injustice. Note, this ad has been authorized by the actions of the Judgetess. Judgetess Judith C. Enza. Note, the knighting of a Judgetess is taken very seriously. Similar to the Supreme Court, it's for life. Important, this term was specifically designed to separate the honorable judges from the dishonorable ones.
I went through the bills. I went through them line by line. I studied the descriptions of the work performed, and I considered the rates charged. Part of that review, frankly, was with an eye to determining who was actually driving the litigation. And of course, for that, I only have the pleadings filed and the descriptions delineated in the bills themselves. I do find the hourly rates charged to be fair. I find the time allotted for the tasks performed reasonable. I find that of the almost $200,000 in legal bills, much is attributable to inappropriate actions on the part of Mr. Stengel.
That knowingly fraudulent statement only related to Bradford G.Y. Carney's bills. The rest of the crime ring, which includes Enza, exceeds $1.5 million, extorted, and the raping of Mr. Stengel's children's childhoods, and feeding the children to a known psychopath. Enza told Kent Krienberg, Leon W. Berg and Dr. Catherine Killeen's bills were outrageous. Marylandgate.com. That was 3 years later, in a case where Mr. Stengel had a prenuptial agreement, where Miss Silisky got what she came in with. Not much. Which was uncontested by both Miss Silisky and Bradford G.Y. Carney. The same exact day, September the 18th, 2013, prior to Enza stating it's Mr. Stengel's doing, on pages 16 to 17, Judge Enza confesses to the exact opposite.
Mr. Rudo, I already know that Ms. Stengel hasn't always been honest. I know that. I know she lied to the police officer because she had Mr. Stengel's phone when she said she didn't. So I know that. And I didn't escape my notice that there were several discrepancies in the financial statements. In fact, in that hearing we had, that lasted several days, it was like every day. I would get a before lunch and after lunch amendment. So, I mean...
Yet, Mr. Stengel is the one most responsible for all the bills? Huh? Zero income statements, and Miss Silisky and Mr. Carney supply Mr. Stengel with the same valid information. Zero. Forcing Mr. Stengel go into the expense and time to subpoena many to find the trails of Miss Silisky's shell games. As you have already learned, nothing ever matches. They all contradict themselves and each other. Mr. Stengel simply organized it to help his own children and to prevent future victims. Judge Enza knowingly, and with foreknowledge, like everything else, falsely disparages Mr. Stengel at every turn.
There are rambling emails and irrelevant subpoenas.
As you will soon learn, it was more than obvious from the very beginning, day one. However, the pre-planned fraud was proven obvious in the first month. Miss Silisky, a violent career criminal, filed fraudulent zero-income statements with the courts on December the 22nd, 2010, suborned by Bradford G.Y. Carney. As seen, you will also notice the creation date of the financial statement is December the 20th, 2010, yet magically signed on December the 15th, 2010, 5 days prior to its creation.
Royston, Mueller, McLean, and Reed, LLP. December 22, 2010. Please docket the enclosed civil domestic case information report, entry of appearance, counter-complaint for absolute or, in the alternative, limited divorce, injunctive and other relief and, financial statement, pursuant to Maryland Rule 9-203, on behalf of Ms. Susan S. Stengel. Bradford Carney. Page number 2. Entry of appearance, Bradford G. Y. Carney and Royston, Mueller, McLean, and Reed, LLP. Financial statement of
Susan Sileski Stengel. Creation date December 20th, 2010. Date filed December 22nd, 2010, at 3:39 p.m.
Income statement.
Gross monthly income $0. 0 cents. Net income from wages $0. 0 cents. Total monthly income $0. 0 cents. Bank accounts. Savings $0. 0 cents. Personal property $0. 0 cents.
Note, apparently, Miss Sileski doesn't even have a nickel in all of her bank accounts, combined. Also worth noting, personal property equals 0.
Total income $0. 0 cents. Total expenses $9,732. Excess, or deficit $9,732.
Miss Sileski has a monthly deficit of $9,732. Surely, Miss Sileski has loans or gifts each month to substantiate the differences between her reported sworn income and expenses. Surely, Mr. Bradford G. Y. Carney would see those loans or gift records in each month as well.
I solemnly affirm under the penalties of perjury, that the contents of the foregoing financial statement, monthly expense list and assets and liabilities statement, are true, to the best of my knowledge, information, and belief. Signed date December 15th, 2010.
Financials created on December the 20th, 2010, and magically dated and signed on December the 15th, 2010, 5 days before its creation. What did Mr. Carney know prior to filing this fraudulent zero income statement, court stamped December the 22nd, 2010, at 3:39 p.m.? Fact, in Miss Sileski and Mr. Carney's quest to manufacture counterfeit orders and generate fraud bills, they have many people sent Mr. Carney false and disparaging emails regarding Mr. Stengel. Comes this email
from Miller's Minuteman Press. Sent Monday, December 20th, 2010, at 3:16 p.m. to Brad G. Carney. Hello Mr. Carney. I just spoke to Susie about a job she was getting done. We print for her.
Note, this, 2 days before Miss Sileski and Mr. Bradford G. Y. Carney files their fraudulent zero income statement, court stamped on December the 22nd, 2010, at 3:39 p.m. confirming their fraudulently involving unsuspecting victims, and their criminal actions are done with both foreknowledge and malice. Take notice of Mr. Carney's own added exhibit number 47, on the lower right. A mere 20 minutes later, at 3:36 p.m., Mr. Carney replies to that very email, and copies Miss Sileski.
From Bradford G. Carney. Sent Monday, December 20th, 2010, at 3:36 p.m. to Miller's Minuteman Press, Baltimore. CC, Susie Sileski.
This confirms Mr. Carney and Miss Sileski had 2 days to sleep on this, prior to committing the crime of perjury and suborning perjury. Note, keep in mind, you are only being provided a very small sampling of what has been compiled, and many more have been provided to this crime ring. Besides the small amount being shown, what you are seeing, such as this email, is dissected in the timeline, as it's chock full of garbage.
From MDInet claims at dllr.state.md.us. Subject, your unemployment insurance claim has been filed. Date, January 27, 2010, 2:31 p.m. to susastengel@me.com. This email is to inform you that you successfully submitted a claim.
What occurred that very same day? Page number 1.
Statement date February 9, 2010. Susan S. A&M Marketing Services account.
Page number 2 notes.
January 28, 2010. BB&T deposit, January 27, 2010. 3619 Ricehurst Town, Baltimore, Maryland. $1,428.22.
There you go. The same exact day, Miss Silisky files for unemployment benefits. She continues business as usual, and handles another A&M marketing and consulting deal, and earns $1,428.22. Let's do a couple more.
A&M Marketing Services, LLC. 3743 Birch Lane. Southern Trust Mortgage, LLC. Neil Swearin. Estimate date, May 4, 2010. Description: Marketing Consulting Services, May through December, 2010. Services are estimated monthly, and include writing and managing monthly e-campaign, updating Twitter and LinkedIn, writing and distributing press releases with follow-up, fielding inquiries from prospective brokers and arranging appropriate meetings with Neil and Scott. Meetings with Neil and Scott and other marketing efforts, as needed. Based on 20 hours per month. Estimate total, $1,000. Terms: Payment, in full, is due at the beginning of each month, prior to commencement of work. To view your estimate online, go to https://sstengelcreativememories.freshbook.com.
Note: this 8-month contract clearly notes A&M Marketing and Creative Memories businesses, plural.
A&M Marketing Services, LLC. P.O. Box 251. Southern Trust Mortgage, LLC. Neil Swearin. Paid. Invoice number, 3. Date, May 12, 2010. To view your invoice online, go to https://sileski65.freshbook.com/code. Services: Marketing Consulting Services, May, 2010. Notes: Thank you for your business. I look forward to working with you. Total, $1,000. Amount paid, $1,000. Balance due, 0.
Note: welcome to the shell game. 1. The address at the top changed to a P.O. box. 2. The account records changed to Silisky65.freshbooks. Let's pay special attention to the notes line.
A&M Marketing Services, LLC. P.O. Box 251. Southern Trust Mortgage, LLC. Neil Swearin. Paid. Monthly retainer number, 4. Monthly retainer date, June 10, 2010. Task, General. Time entry notes, Marketing Consulting Services. June, 2010. Total, $1,000. Amount paid, $1,000. Amount due, 0. Notes: Thank you. It is a pleasure working with you.
Note: the online records line is gone.
A&M Marketing Services, LLC. P.O. Box 251. Southern Trust Mortgage, LLC. Neil Swearin. Paid. Monthly retainer number, 6. Monthly retainer date, July 3, 2010. Item: Service. Description: Monthly marketing retainer for July 2010. Total, $1,000. Amount paid, $1,000. Balance due, 0. Notes: Checks should be made payable to Susan S. Stengel, A&M Marketing Services.
Note: she added her name to the payable to line.
A&M Marketing Services, LLC. P.O. Box 251. Southern Trust Mortgage, LLC. Neil Swearin. Paid. Monthly retainer number, 7. Monthly retainer date, July 20, 2010. Item: Service. Description: Marketing Consulting Services for the month of August. Total, $425. Amount paid, $425. Amount due, 0. Notes: this August invoice has been modified to reflect the hours worked. Documentation is available at your request. A&M Marketing Services, LLC. P.O. Box 251. Southern Trust Mortgage, LLC. Neil Swearin. Paid. Monthly retainer number, 13. Monthly retainer date, September 1, 2010. Task: Email marketing. Time entry notes.
Note: we will note the different dates.
September 5, 2010, September 6, 2010, September 7, 2010, September 8, 2010, September 10, 2010, September 14, 2010, September 19, 2010, September 21st, 2010, September 27th, 2010, September 29th, 2010. Total, $620. Amount paid, $620. Amount due, 0. Terms, payment, in full, is due at the beginning of each month, prior to commencement of work. Please make checks payable to Susie S. Stengel. Thank you.
Note: please make checks payable to Susie S. Stengel. After this invoice, stating to write checks in her name only, they all magically disappear. Mr. Neil Swearen ignored the subpoena sent by Mr. Stengel. He was called to come to court. When he testified under oath, he committed perjury. Again, these are but a very small sampling provided to the experts on the court. Mr. Neil Swearen obviously committed multiple counts of perjury, although Mr. Swearen's own contract clearly states
Marketing consulting services, May through December, 2010.
Therefore, 8 months, the monies disappeared, with the fading out of the corporation, in cooperation with the make checks payable to. Besides, isn't it illegal to pay an individual for work done by or under the umbrella of a corporation? This more than obvious scam was unfolded right in front of Judge Judith Cienza. Yet, in a classic allegations equals confessions, Enza states,
Mr. Stengel keeps coming up with money. Now, I can't tell you exactly where it is. I really can't. I can't point to an exhibit that says exactly where it is.
Basically, we have Ms. Zero Income, am unconscionable, enrolling a carrier. Not just any carrier, one that is deluded enough to commit crimes. Therefore, also involving Mr. Swearen's wife and children.
Not my problem. Right, Mr. Carney? Right, the Honorable Judith Enzer? Right, the Honorable Kathleen Cox?
Also obvious, the address of the contract changed to a post office box. Here are just a couple of pages from Miss Sileski's hard drive backup, relating to her French tour business. Includes Miss Sileski's own spreadsheet, and some notes. 10 people went on this trip. We will note just a couple on page number 2. Focusing on the payments.
Profit. $14,672. Barbara Ann Greenberg. Paid, November 10, 2010. $1,333.04. Madison Rose McCann. Paid, November 10, 2010. $1,333.04. Megan Lynn McCann. Paid, November 10, 2010. $1,333.03.
Note: Ms. McCann is the same person. Miss Sileski outright refused to go to Ms. McCann's mother's funeral, which was local. Mr. Stengel was upset and went without her. Miss Sileski also refused to go to Mike Stockman's wife's funeral in Boston and falsely blamed others who live in California.
I'll tell you what.
By the way,
I'll give you the cameras when you give me my hard drive off the servers. I'll tell you what.
By the way,
I'll give you the cameras when you give me my hard drive off the servers.
2 days later. One day after that criminal act.
Find Mark 7 on whatever computer is Mark 7.
I think Mark 7 is his laptop, which he has with him.
And then he's got it, if he's a...
But he's got to have backups on stuff, right?
Right, that's what I'm assuming is on these drives here, and also that window. Now you're not in trouble for getting into his account, are you? Because I would crack his password for you to do this. Now you're not in trouble for getting into his account, are you? Because I would crack his password for you to do this.
The observations of adult professionals in their specialized fields, given the task of fighting reality at all costs, and the ways they go about it, by itself is worth the price of admission. Although they collectively make it appear they are arguing with Mr. Stengel, in reality, they are arguing with reality, and their own words and actions, in the face of reality.
Financials created on December the 20th, 2010, and magically dated and signed on December the 15th, 2010. 5 days before its creation. 3 months later, on March the 21st, 2011, to have Mr. Carney's fraudulent bills paid, Mr. Carney and Miss Siliski filed a motion for legal fees, which included the same exact zero income statement. What did Enza really know? Being her pathological self, we will let her tell you one small part, in one of her own confessions. Throughout the years, and meticulously documented by Mr. Stengel, what's more than obvious is, they all, collectively had the same wrong answers. While all the hard evidence, backed up multiple times, and often in multiple ways, matched Mr. Stengel, his children, ex-wife, the months of videos, running in the home, and even Mr. Karseski, in his 148-page package to the state of Maryland, who afterwards dropped, what was their second fraudulent criminal case. The second one, where Mr. Stengel was falsely and fraudulently incarcerated for providing evidence of a crime ring's crimes. While incarcerated, Mr. Stengel had a visitor, U.S. Federal Postal Agent. The agent stated Mr. Leon W. Berg and others were steadfast on having Mr. Stengel federally prosecuted. He said especially, Mr. Berg. Mr. Berg left out that, for mailing evidence of his crimes to warn others, part. Therefore, Mr. Berg knowingly lied to a federal agent. The agent mentioned being bothered or harassed by Mr. Berg, trapped in their own meticulously documented crimes. Not one of them has ever taken responsibility for anything, therefore forced for years to continue with their crimes, even committing more crimes, to cover up their previous crimes. Many by way of hoodwinking and conning others. Some by way of fraudulent gag orders. Frauders. Many conspired with, and even signed by Enza herself. Therefore, attempting to immunize herself, as well. Judith C. Enza has been warned, by the Judicial Disabilities Commission, directly relating to Mr. Stengel's cases, plural. Enza was recused from Mr. Stengel's cases. More recently, Kathleen G. Cox picked up where the warned Enza left off. Also, Cox keeping the case, specially assigned to herself. Specially assigned, translated is, alienated. Alienated from everyone, even from other judges. After Enza, these hide-the-fraud attempts are being handled by Kathleen Cox, whose courtroom is where it all began, on November the 29th, 2010. November the 29th, 2010, Miss Siliski files her first fraudulent protective order. Mr. Stengel was unaware, and met with a mediator, earlier in the day. Mr. Stengel is evicted from his own home, by 2 sheriffs. The December calendar shows November the 29th, 2010 as well. That November the 29th, 2010 fiasco is also meticulously documented in Series Number 1, Episode Number 1. Judge this Kathleen Cox's actions in late 2015 and 2016 were done, even after Mr. Stengel provided Kathleen Cox with episodes number 1 to number 7 of 16+ episodes in Series Number 1. Kathleen Cox will also be recused from Mr. Stengel's cases. One thing they all did collectively was disparage Mr. Stengel in regards to things and actions they all knew to be false, and made well aware, which included provided detailed information. It was in fact the opposite. You will hear Judge this Judith Enza falsely disparaging Mr. Stengel, stating rambling emails and irrelevant subpoenas. The same known falsities surrounding the enormous number of emails allegedly sent by Mr. Stengel. Again, you will notice the case is the exact opposite, as Miss Siliski and Mr. Carney hoodwinked and conned people to send false disparaging emails to Mr. Carney, generating more fraud bills. Emails from multiple states, and even other countries. As if someone in Canada, or Oregon, would have a clue as to the realities of what really transpired in someone's home in Maryland. Besides, they all contradict the months of video running inside the home. However, their entire crime ring collectively agrees it was Mr. Stengel's doing. The email falsities is documented in the 400 emails or 84 emails presentation. The reason so many required their own presentations. What you will find astounding is the level and depth this crime ring would go to, went to, and must continue to go to, forever, in order to obtain their agendas. Are you simply witnessing the actions and reactions of trapped rats? Before we get started, we will do a few brief notes of summaries of just a couple events leading up to Mr. Carney getting involved. 8 days later, and December the 7th, 2010, the trial where Miss Siliski had to prove her many outrageous allegations. Mr. Stengel outright rejected Ms. Silesky's plea deal, offered before trial. Ms. Silesky lost the case. However, involving court, Kelly Weinberg, Betsy R. Stryker, Sally Silesky, Matthew Silesky, Eileen Rosenberg-Shear, and others. We read Mr. Carney's retainer agreement. This is valuable information, and the reason we read it in its entirety, lasting 4 minutes. Royston, Mueller, McLean and Reed, LLP. December the 17th, 2010, via electronic mail to anivatafrance@gmail.com, and first-class mail.
Dear Ms. Stengel, I enjoyed meeting with you and Kelly Weinberg in my office yesterday afternoon, to discuss the facts and circumstances surrounding your marital separation from Mark Leslie Stengel, and the email harassment that you and your friends have been experiencing at the hands of your estranged husband. You have asked me to undertake your representation throughout your marital separation, and to secure a judgment of absolute divorce on your behalf from the Circuit Court for Baltimore County. I am happy to undertake this representation, and will take all steps, which I deem, to be both reasonable, and appropriate, to secure custody of your 2 minor children, Alexander and Maya, secure an award of alimony pendente light, and, if appropriate, an award of permanent alimony, and to equitably divide your marital property. I have advised you that all legal fees accruing to you throughout the course of my representation, will be calculated at my standard hourly rate of $375, or the hourly rates of any of my firm's attorneys, who I may ask to work on your divorce proceeding under my supervision. Currently, the firm's partners' rates range from $275 to $375 per hour. Our associate attorney's time is billed at rates of $150 to $225 per hour, and our paralegal's time is billed at $150 per hour. Please bear in mind, that the hourly rates of the firm attorneys, and paralegals, are reviewed on an annual basis and, accordingly, you can anticipate an adjustment in those rates on, or about January 1st of each year. In addition to legal fees, I would ask that you agree to reimburse the firm, for any out-of-pocket expenses we may incur on your behalf throughout the course of our representation. These expenses include, but not necessarily limited to, photocopies, long-distance facsimile transmissions, overnight mail/Federal Express, messenger/delivery services, parking, travel at business class rates, deposition transcripts, expert witness testimony, etc. Please bear in mind, that some of the expenses that you will be asked to repay, exceed the firm's actual costs, in an attempt by us, to defray the expenses associated, with providing our clients with these types or services. In the event that I anticipate incurring large expenses for items such as deposition transcripts, and/or expert witness testimony, I reserve the right to ask that you deposit a sum of money into the firm's escrow account, which, in my sole opinion, will be sufficient to pay these types of expenses in full. As a retainer against your legal fees and costs, I have asked you to remit the sum of $7,500 which will be deposited into the firm's escrow account, and debited on a monthly basis as fees accrue, and/or costs are incurred. In the event that your retainer is exhausted, you would upon request, agree to immediately replenish it to its original amount, on as many number of occasions as become necessary, until such time as your representation is concluded. In the event that your retainer is not replenished upon request, I reserve the right to withdraw from my representation. You will receive an itemized bill from me on a monthly basis, which I would ask that you carefully review and contact me should you ever have any questions, or concerns, regarding any line item appearing thereon. In the event that I have not heard from you within about 1 week of your receipt of my monthly invoice, I will assume that you find your bill to be in proper order. As far as I have been able to determine, there is no present or past representation, which creates a conflict of interest preventing me from representing you. If in the future I conclude, that continuing to represent you would constitute a conflict of interest which cannot be resolved under the Maryland rules of professional conduct, I retain the right to withdraw from my representation. I look forward to working with you throughout the course of your marital separation and divorce proceedings, and trust that the terms and conditions of this letter agreement meet with your approval. To evidence your consent to the terms of my engagement, please date and sign the enclosed copy of this correspondence where indicated, and return it, together with your check to my order, in the amount of $7,500, to me in the envelope which I have enclosed for your convenience. Very truly yours, Bradford Carney. Read and accept this, blank, day of December, 2010. Susan Silesky Stengel.
Note: for this presentation, we will skip all the disparaging and false statements by Mr. Carney, and note: 1. Sent to anivatafrance@gmail.com. Miss Silesky's French tour business. 2. Mr. Carney's rate is $375 per hour. 3. Reimburse out-of-pocket expenses. 4. A very strange and curious clause.
Please bear in mind that some of the expenses that you will be asked to repay exceed the firm's actual costs, in an attempt by us to defray the expenses associated with providing our clients with these types or services.
Note, I believe the word defray says it all. Add to that.
Associated with providing our clients with these types or services.
5. Submit $7,500 retainer. 6. Replenish retainer as requested. 7.
You will receive an itemized bill from me on a monthly basis, which I would ask that you carefully review and contact me should you ever have any questions or concerns regarding any line item appearing thereon. In the event that I have not heard from you within about 1 week of your receipt of my monthly invoice, I will assume that you find your bill to be in proper order.
Focusing on.
Contact me should you ever have any questions or concerns regarding any line item.
$200,000 of bills. Any questions or concerns, ever? 8. What appears to be a get the heck out clause for unethical acts by Mr. Carney. 9. And
to evidence your consent to the terms of my engagement, please date and sign the enclosed copy of this correspondence where indicated and return it, together with your check to my order in the amount of $7,500.
Fact.
To evidence your consent to the terms of my engagement, please date and sign.
Clearly, it is not dated. Furthermore, the email address, amiva2france@gmail.com, is a French tour business Miss Siliski was running, and had already collected several thousands of dollars from multiple people. This noted by Mr. Carney himself, 5 days prior to Miss Siliski's fraudulent zero-income statement on December 22, 2010. Besides that and other businesses Miss Siliski was earning income from, Miss Siliski, in 2010, fraudulently collected over $20,000 in fraudulent unemployment income. Apparently, if anyone has zero income, Royston, Mueller, McLean and Reed, LLP, and Bradford G.Y. Carney, will be happy to do all the work you need or want. December 17, 2010, Mr. Carney, drafts $7,500 retainer agreement letter for Miss Siliski. Let's look at how this billing relationship began. Retainer bill and payment history, provided by Bradford Carney. Retainer was $7,500. This next part may seem laborious. That's because it is. There are numerous oddities and inconsistencies in Mr. Carney's bills. Without explaining them, the numbers will not add up, and you will be left confused. It's also part of their shell games. Amounts in wrong places, noted at incorrect times, etc. These are not mistakes. Rather designed this way. While pointing out their nonsense, we correct most of the issues. 1. On December 21, 2010, payment of $4,500 from her 80-year-old mother, Sally Siliski, a.k.a. the money launderer. 2. On December 27, 2010, payment of $3,000 with zero income, Susie Siliski. 3. On December 31, 2010, legal bill invoice number 42330, for $10,746.35. Balance due, $3,246.35. 4. Noted here on January 11, 2011, legal bill invoice number 42555, for $225. However, on the actual bill, it is noted on December 31, 2010. After correcting their error, the total billed on December 31, 2010, is $10,971.35. Balance due, $3,471.35. And already, per the retainer agreement, as of December 31, 2010, and only 2 weeks in, Miss Siliski will need to pay the $3,471.35, plus the $7,500 retainer. Translated, Miss Siliski will need to pay the $10,971.35. This, with sworn zero income, and swearing to not be employable. And Mr. Carney took this case, even with the prenuptial agreement, where his client gets what she came in with. Not many options for Mr. Carney, are there? Sit back and relax. You have heard of paint by numbers. This will be like fraud by numbers. Sally Siliski pays $4,500. How is it possible? Let's look at the larger picture. Initial account deposit was from Miss Siliski's mother, Sally Siliski, on December 21, 2010, as noted in this provided document. via one of Mr. Stengel's subpoenas. Sally Siliski, aka the money launderer. Note, Miss Siliski added her name to all of her mother's accounts, and even her home, stating to protect her inheritance from her brother Bobby Siliski. Where did this over 80 years old, fixed income senior, get $4,500 from, on December the 21st, 2010? Glad you asked. Senior checking account, check number 889, $4,500. Page 1. Page number 2 notes, December the 20th, 2010, $4,000 counter deposit. Just one day earlier. Where did this $4,000 come from? Let's look at the following statement. The next month, on January the 20th, 2011. Notes, account close out. Aren't closing senior bank accounts common? No. The odds an over 80-year-old woman closes their long-term account, where her paychecks were auto-deposited, at this particular time. Welcome to the shell game. Reality, if that were the needle, there are hundreds of them, and as many haystacks. Almost forgot to mention. An insane number are documented. However, there are always more rats behind the walls. Miss Siliski and Mr. Carney's summary of monthly bills. Amount paid column and amount billed column, both noted. Also, the balance end column on the far right. How is Mr. Carney getting paid? Focusing on the notes at the very bottom. Noting, these amounts, which were all that was provided, are just through August 2012. Billed $179,974.81. After January the 18th, 2011 payment. Total paid $5,344.61. Fact, the account had a positive balance for... Hold on, let's do some math here. Here we go. 40 days. That's without considering the so-called required retainer. However, we will ignore that. The total paid $5,344.61 is actually not an accurate number. It's less. Much less. Disturbingly less, but not because of the amount.
There are rambling emails and irrelevant subpoenas.
The subpoenas did return valuable information. Why else would Miss Siliski blast out an email to have people ignore the subpoenas, while disparaging Mr. Stengel, which is constant in the default? That email is in direct violation of the December 22, 2010, court order. The order was signed by Judge Judith Enzer. Just one of Miss Siliski's several dozens of contempts. That email was also provided from responses to the subpoenas Mr. Stengel was forced to send out. Staying focused on this very specific topic, the legal bills. Next is a check written from Janet Schatzman, aka Aunt Janet. Dated June 15, 2011, in the amount of $5,000. It notes for legal services. Notes, legal services. Also worth noting, it is not written to her attorney or firm. Come out wherever you are.
It's not here. Are you surprised?
Huh? Is that a joke? Regardless, she didn't even pay the $5,344.61. She got others too. Was there an urgency presented to obtain those funds? By this, we are sure of one thing. Miss Siliski intentionally did not pay her legal bills. Having been provided this subpoenaed response from Janet Schatzman, Mr. Carney was well aware of it. Let's repeat that. Having been provided this subpoenaed response from Janet Schatzman, Mr. Carney was well aware of it. Which tells us, Mr. Carney never intended to get his money from Miss Siliski, regardless of the situation at hand, or the parties involved. This is his business. The participants, mother, father, children, witnesses, schools, whatever, are 100% completely irrelevant. Also evident by the retainer never being paid as a retainer, or above water. Nor was anything else, ever. The balance end column makes that obvious. What did she do with the $5,000? Miss Silisky Stengel's 2011 tax return, form number 8880, listed as number 1, where it notes, traditional and Roth IRA, contributions for 2011, $5,000. Therefore, with zero income, Miss Silisky was not only fraudulently playing poor to the courts, aka the victim, she testified, she took furniture from Jewish Family Services and so-called friends, among many other things, from other charitable organizations, contributed to for the needy, including food and money, from many people as well, like fraudulent school grants, and much more. Miss Silisky was also conning her over 80-year-old Aunt Janet, for legal fees, and the $5,000 winds up in her IRA, the same aunt who let Miss Silisky move into her home. The same aunt, who many years earlier, let both Miss Susan Silisky and Sally Silisky live in her home for about 2 years. There are many other checks from her over 80-year-old Aunt Janet Schutzman, to Miss Silisky, or for Miss Silisky, who plays the victim, while victimizing her prey. How and why is it so easy? Simple. Janet Schutzman's conscience is being used against her. Isn't that right, Miss Silisky? Class, unconscionables, can sit at your dinner table, eat your food, and look right at you, after placing a knife in your back. The problem, you can't tell by looking at them.
Why?
Because they have no conscience. They don't feel bad. The acts of a conscience, such as empathy, love, caring, result in automatic movements, such as facial expressions. Without a conscience, what you are reading is what their brain is selling. However, if you listen and pay attention, that's all matter of fact. Without a conscience, what you get is not emotion. It's more like a business meeting. Often, not always, people are hard to read. Like Dr. Catherine Killeen. Not hard to read, but impossible. Why? Because there is nothing to read. What you are accustomed to reading, emotions, reactions, facial expressions, a glance at a specific time, etc., which come from emotions. The reality is, Dr. Catherine Killeen is dead on the inside. Dead. D-E-A-D, dead. As you will learn. These extremely high-level unconscionables will kill your dog, then go help you look for it. Meanwhile, this $5,000 contribution, while still collecting unemployment in 2011, which was lied to in court, but that's much later. Also while making loads of money. Anyone interested in adopting a niece, or her mother, Sally Silisky? Okay, let's back up a bit. So, where did the $4,000 cash from Sally Silisky originate? Where did it come from? Well, always remember, there is always more. You're just being teased by this and other presentations. Let's add one more small piece to this fraud puzzle.
There are rambling emails and irrelevant subpoenas.
We will only look at what relates to what we have seen so far. It will be more clear why Miss Silisky or Bradford Carney refused to provide basic information while telling the courts it was Mr. Stengel doing just that. Mr. Stengel's subpoenas returned this. As a teaser, we have this bank statement dated January the 11th, 2011, Miss Silisky's zero income statement, page number 1 notes, A&M, Marketing Services, account. Living with, and while abusing her over 80-year-old, Aunt Janet. On December the 20th, 2010, Miss Silisky gets $4,000. Now, playing poor, a requirement, gives the $4,000 to her adopted mother, Sally Silisky, who launders the money in her account. Pays Mr. Bradford G.Y. Carney, and that account gets closed. Even though her direct deposits went into that account. Welcome to the criminal shell game, starring Susan Silisky and Sally Friedberg Silisky. Remember the name, Friedberg, as you will throughout it all, see how many so-called relatives, these two, the adopted daughter and adopted mother, criminals, have conned. Now, let's look what's behind the fraud curtain below. Remember, there is always more. And you are only being provided the dust, from only one needle, of the hundreds of needles, in as many haystacks. Surely you remember, Miss Silisky signing her fraudulent zero-income statement on December the 15th, 2010. On that very day, Miss Silisky deposits $113. How magical is this? This is only one of Miss Silisky's many accounts. We should also take a moment to remember what Miss Silisky noted in her sworn filing, filed by Bradford G.Y. Carney. Bank accounts and savings equals $0.00. Let's detail the fraud. Buckle up. Note, the top of the page notes, escrow/retainer balance carried forward $7,500. However, this is incorrect, as noted in the bill and payment history. 1. There was never an escrow balance, period, let alone $7,500. 2. We already know the initial payment was not made until sometime during December 21, 2010. 3. Therefore, applied at day's end, with the rest of the transactions. December 2010 billing, page number 1. Important note, do not pause any of the 3 pages to read. Some need to remain in the timeline for this fraud billing course, and are coming up shortly. 1. December 14, 2010, to December 20, 2010. A. Mr. Carney billed for 8.40 hours, for $3,150. Note, before he received any money. B. Received $4,500 payment from Sally Siliski on December 21, 2010. Note, December 21, 2010, after payment is applied. Account balance is $1,350. Before the day began. C. The balance is eaten up before day's end. Yet billed for $1,950. New balance is negative $600. Underwater. The account never comes above water for even 1 day, nor does it ever. The day is not over. Page number 2 contains yet another December 21, 2010, line item. Let's continue. Stay buckled. Page number 2. Reminder, not to pause to read line items, for now. D. Also on December 21, 2010, JDR billed for 1.60 hours, at $150 per hour, comes to $240. Added to the negative $600 balance. The day ends with a balance of negative $840. That's after payment has been applied. E. We will come back to this entire audio/video part. F. After December 21, 2010, Mr. Carney billed 8.60 hours, for $3,225. J. Ruth billed 0.50 hours, for $75. Total billed $3,300. Add past negative balance of negative $840. New account balance is negative $4,140. And what about the retainer? Just kidding. December 27, 2010, payment received $3,000. New balance due negative $1,140 as of December 27, 2010. Facts. 1. Retainer was never provided as a retainer. Therefore, is the contract invalid. 2. Account had positive balance for 0 days. 3. Account never brought current, let alone with the $7,500 retainer. Yet, the work continued, as noted below the lower line, and on to the following page. As a quick example, FYI, on December 22, 2010, a line item notes.
View entire video/audio tape of kitchen incident on September 16, 2010.
Billed 0.20 hours for $75. 0.20 hours is 12 minutes. Legal billing education, billed in 6-minute increments. Therefore, 0.20 would be from 7 to 12 minutes to generate 0.20 hours. At that point, Mr. Carney only had the attachment from the email. Paying special attention to the words
entire video/audio tape.
Let's take a look at the entire Mr. Carney references and billed $75 for, which he billed for 12 minutes. That's it. 5 seconds. And $75 billed to watch his client's violence. Note, we will not do this very often, however, you may recall the 484 emails mentioned earlier, and that scam. If we look down a few lines, Mr. Carney's bill notes.
December 23, 2010, BGC, read, study, and print 38 emails from Susie, and many third parties. Draft various email responses.
Billed 4.00 hours, for $1,500. Note, for harassing and wrongfully involving others, to assist Miss Siliski in abusing her own children. 38 emails, in one shot. Mr. Carney then insists he must respond to ring up more fraud bills. And they all collectively have the same wrong answers. It's Mr. Stengel's doing. Going line by line makes that scam more than obvious. Page number 3. Mr. Carney's bill total and balance due doesn't match. The reason is due to that December the 31st, 2010, $225 entry we noted earlier. Although not reflected here, it is in the overall billing summary. The amounts on this page number 3 are $225 short. It further notes, expenses, $43.85. End of December 2010, balance is negative $3,471.35. That does not include the $7,500 retainer still due. January 2011, bill. Page number 1. Again, do not pause to read line items at this time. 1. Notes balance due from previous month negative $3,471.35. As there was more billing after Ms. Zaleski's $3,000 payment on December the 27th, 2010. Note, the balance carried forward from retainer with a positive amount is incorrect, as it applies Ms. Zaleski's payment not made until January the 18th, 2011, prior to January billing. January 2011 bill, page number 2. 1. Through January the 14th, 2011, Mr. Carney billed 10.70 hours for $4,012.50. J. Ruth billed 1.80 hours for $270. Total amount billed this month through January the 14th, 2011 is $4,282.50. Account balance through January the 14th, 2011, negative $7,753.85. Looking at the early bill and payment history page provided by Mr. Carney. 2. On January the 18th, 2011, payment of $5,000 with zero income. 3. With the January 18th, 2011, payment, balance due is negative $2,753.85. After payment is applied, account is still negative, yet the work continues. January 2011 bill, page number 3. The billing continues. Ending account balance is negative $6,614.40. It also notes, expenses, $58.05. Reality, the approval by Judge Judith Enza, that line-by-line lady, who 3 years later said, Mr. Carney's bills were both fair and reasonable. And Stephen Feder, the expert who swore Mr. Carney's bills were both necessary and reasonable. Note, really Mr. Feder. And that was 2 years later. Why would anyone need to go beyond the first couple of weeks in Mr. Carney's bills? Let's zoom out for this quick review of events. November 29, 2010, Ms. Zaleski files her first fraudulent protective order. Mr. Stengel was unaware and met with a mediator earlier in the day. Mr. Stengel is evicted from his own home by 2 sheriffs. 8 days later, and December the 7th, 2010, the trial where Ms. Zaleski had to prove her dozens of false and outrageous allegations made 8 days earlier in order to obtain her emergency protection. Mr. Stengel outright rejected Ms. Zaleski's plea deal offered before trial. Mr. Stengel thought, with 100% false bullshit, good luck proving any of the several dozens sworn to under oath. Ms. Zaleski lost the case. However, she involved in court Kelly Weinberg, Betsy R. Stryker, Sally Zaleski, Matthew Zaleski, Eileen Rosenberg-Shear, and others. Ms. Zaleski refers to them as witnesses. Mr. Stengel refers to them all as just another group of victims, used as needed. December the 15th, 2010, Mr. Carney is introduced to Ms. Zaleski by Andy and Kelly Weinberg. Mr. Carney is already generating bills. December the 16th, 2010, Mr. Carney initially meets with Ms. Zaleski and Kelly Weinberg in Mr. Carney's office. December the 17th, 2010, Mr. Carney drafts $7,500 retainer agreement letter for Ms. Zaleski. Important. Mr. Stengel has an uncontested prenuptial agreement where Ms. Zaleski gets what she came in with. December the 20th, 2010, Sally Siliski, Susan's 80-year-old adopted mother, deposits $4,000 all cash money into her own bank account. $3,150 already billed by Mr. Carney before he received any payment whatsoever. December the 21st, 2010, $4,500 partial retainer deposit made by Sally Siliski. Account balance negative $840, which includes the funds not cleared. December the 22nd, 2010, Miss Siliski and Bradford Carney file sworn, zero income statement. Important. Uncontested prenuptial agreement plus sworn zero income. How is Mr. Carney getting paid? December the 27th, 2010, $3,000 partial retainer deposit made by Susan Siliski. This with zero income. Account balance negative $1,140, which already includes uncleared funds. December the 28th, 2010, account start balance negative $1,140, which already includes the $3,000 deposit. Mr. Carney on the 28th billed for $862.50. New balance negative $2,002.50. December the 29th, 2010, Mr. Carney continues and billed for $787.50. New balance negative $2,790. December the 30th, 2010, Mr. Bradford G.Y. Carney is busy and billing. Mr. Carney is busy billing. December the 31st, 2010, statement shown, Mr. Bradford G.Y. Carney already billed for $10,971.35. Past due $3,471.35 plus the $7,500 retainer. Welcome to Mr. Carney's provided monthly bill summary. Miss Siliski should be paying the past due $3,471.35 plus $7,500 retainer. Total due $10,971.35. January the 6th, 2011, Mr. Leon W. Berg begins as best interest attorney for the minor children. January the 6th, 2011, the very day Mr. Leon W. Berg begins, Mr. Carney sends out this email, which includes going to Mr. Berg, where Mr. Carney's entire email states,
"I'm just getting warmed up."
This, after yet another $1,425 billed in the first 6 days of January, and already billed $12,396.35. And, Mr. Carney clearly documents,
"I'm just getting warmed up."
January the 7th, 2011, Dr. Catherine Killeen begins as child custody evaluator and parents extensive psychological tests. Note, in the grand scheme of things, pun intended, Mr. Leon W. Berg and Dr. Catherine Killeen were involved from very early on, just 3 weeks after Mr. Carney began. Dr. Catherine Killeen, as an expert, swears under oath on December the 1st, 2011. Questioned by Leon W. Berg, best interest attorney. January the 14th, 2011, January the 1st, through the 14th, Mr. Carney billed 10.70 hours for $4,012.50. J. Ruth billed for 1.80 hours for $270. Total billed $4,282.50. Grand balance owed through January the 14th, 2011. Negative $7,753.85. That does not include the $7,500 retainer. with $10,971.35 billed through December the 31st, 2010. Total payments made, $7,500. Balance due, $3,471.35, plus through January the 14th, 2011, the added amount of $4,282.50 equals total due, $7,753.85. January the 18th, 2011, $5,000 deposit by Miss Silisky, with zero income. New account balance is negative $2,753.85. That does not include the $7,500 retainer. As noted in Mr. Carney's own bill and payment history, as you can see, the payment was received on January the 18th, 2011. Yet, magically applied at the beginning of the month, 18 days earlier. Also on Mr. Carney's own worksheet, you will notice that very $5,000 deposit is recorded here, using some bizarre accounting principles. January the 20th, 2011, Sally Silisky closes account. 80-year-old woman curiously closes her long-term direct deposit account. Really? Sally Silisky, known as the money launderer, plays what is known as the shell game. January the 31st, 2011, statement notes January bills total $8,143.05. Balance due $6,614.40. That is without considering the retainer. Miss Silisky filing zero income statements, and Mr. Stengel has a prenuptial agreement, where Miss Silisky gets only what she came in with, almost nothing. Neither Miss Silisky or Mr. Bradford G.Y. Carney contested the prenuptial agreement. How is Mr. Carney planning on getting paid? In February 2011, Miss Silisky paid $0.00, yet Mr. Carney rang up bills for $8,412. Let's add some more reality to all of their frauds. What you will see is a summary listing of deposits by Miss Silisky, and just into two of her accounts. Note, although most account statements end at the end of the month, Miss Silisky, in order to facilitate the shell game, has hers end in the middle of the month. However, let's ignore that deceptive practice and follow along. We use the month statement as that month. You will see, it really does not matter. But, a nice try by Miss Silisky. Although Miss Silisky paid $0.00 in February 2011, Miss Silisky deposited $5,253.71. Apparently, that was okay. With Mr. Bradford G.Y. Carney, and Royston, Mueller, McLean and Reed, LLP. Account balance, negative $15,026.40. On March the 21st, 2011, Miss Silisky and Bradford G.Y. Carney filed a motion for legal fees to have Mr. Stengel pay the fraudulent bills. On December the 22nd, 2010, Miss Silisky and Bradford G.Y. Carney filed Miss Silisky's first fraudulent zero-income statement. Now, 3 months later, they filed the same zero-income statement. This, in a covert attempt to have their fraud bills paid by Mr. Stengel. In 2011, Miss Silisky was still fraudulently collecting unemployment compensation and running multiple businesses. During the same month, March 2011, Miss Silisky paid a whopping $469.61 towards her legal bills, yet Mr. Carney rang up bills for $5,185.50. However, Miss Silisky deposited $3,686.53. Apparently, that was okay with Mr. Bradford G.Y. Carney. Account balance, negative $19,742.29. In April 2011, Miss Silisky only paid $500. Yet Mr. Carney rang up bills for $10,378.20. However, Miss Silisky deposited $8,094.98. Apparently, that was okay with Mr. Carney. Although we are in April, and due to Miss Silisky constantly creating confusion, we will backtrack just a bit. We look at the details of that April 2011 statement. Although Miss Silisky and Bradford G.Y. Carney filed for legal fees on March the 21st, 2011, and included the same zero income statement, we can see the realities of their frauds right here. If you're not buckled, buckle up. Statement date, April the 12th, 2011. Page number 1. You will notice, with zero income, and currently unemployable, along with A&M Marketing Services, still living with her Aunt Janet. Deposits in the amount of $8,040.47. On page number 2, you will notice, with zero income, she is making payments. Lots of payments. Just not towards her legal bills. Payments to others, in the amount of $5,107.71. If we take a closer look, on the very same day, Miss Silisky and Bradford G.Y. Carney, on March the 21st, 2011, in yet another sworn filing, filed for legal fees, and included her zero income statement, we can clearly see that. On March the 21st, 2011, Internet Payment ePay, Chase, for $1,258.26. Also on March the 21st, 2011, BB&T Online Bill Payment, Online Payment, Chase Card Services, for $800. Translated.
Go team, go!
Account balance, negative $29,620.49. Besides, Mr. Carney's columns are not in correct order. Basic math seems to be a problem as well. Miss Silisky filing zero income statements, and Mr. Stengel has a prenuptial agreement, where Miss Silisky gets only what she came in with, almost nothing. Neither Miss Silisky or Mr. Bradford G.Y. Carney contested the prenuptial agreement. How is Mr. Carney planning on getting paid? Sam Crystal conferences with Bradford Carney regarding outstanding fees. Mr. Carney's bill notes.
May 31st, 2011, SMC, Samuel Crystal, conference with B. Carney, call with client regarding criminal charges, contempt, emails, meeting with B. Carney and outstanding fees.
Billed 0.50 hours, for $100. Note, obviously, they have been working on the criminal scam from day one as well. For now, we focus on the last part.
Meeting with B. Carney and outstanding fees.
Note, this first mentioned after several months, and nearly $35,000 owed, which does not include the $7,500 retainer. Fact, this is the first and last time outstanding fees are ever mentioned. First, $950 allegedly owed goes ignored. Then we have Samuel Crystal, who recently became a lawyer, working under Bradford G.Y. Carney. Apparently, what followed that conference was a crash course for the youngster, Mr. Crystal, by Mr. Bradford G.Y. Carney himself. In fact, it is this very course currently being reviewed. In May 2011, Miss Silisky paid $0.00, yet Mr. Carney rang up bills for $6,142.15. However, Miss Silisky deposited $8,378.12. Apparently, that was okay with Mr. Carney. Account balance, negative $34,812.64. In June 2011, Miss Silisky paid $0.00, yet Mr. Carney rang up bills for $12,737.70. However, Miss Silisky deposited $3,682.63. Apparently, that was okay with Mr. Carney. Add to that, the check written from Janet Schutzman, aka Aunt Janet, dated June the 15th, 2011, in the amount of $5,000. It notes for legal services. This further confirms Mr. Bradford G.Y. Carney's lack of concern regarding the mounting outstanding legal fees, just noted by Samuel Crystal a mere 2 weeks earlier. Account balance, negative $47,550.34. In July 2011, and in an unprecedented event, Miss Siliski paid $2,000. However, Mr. Carney rang up bills for $8,505.45. However, Miss Siliski deposited $12,241.28. Apparently, that was okay with Mr. Carney. Account balance: negative $54,055.79. Miss Siliski filing zero income statements, and Mr. Stengel has a prenuptial agreement, where Miss Siliski gets only what she came in with, almost nothing. Neither Miss Siliski or Mr. Bradford G.Y. Carney contested the prenuptial agreement. How is Mr. Carney planning on getting paid? In August 2011, Miss Siliski paid $0.00, yet Mr. Carney rang up bills for $9,458.80. However, Miss Siliski deposited $15,195.83. Apparently, that was okay with Carney. Account balance: negative $63,514.59. In September 2011, Miss Siliski paid $0.00, yet Mr. Carney rang up bills for $14,685.15. However, Miss Siliski deposited $7,279.16. Apparently, that was okay with Mr. Carney. Account balance: negative $78,199.74. In October 2011, Miss Siliski paid $0.00, yet Mr. Carney rang up bills for $5,999.25. However, Miss Siliski deposited $6,251.60. Apparently, that was okay with Mr. Carney. Account balance: negative $84,198.99. In November 2011, Miss Siliski paid $0.00, yet Mr. Carney rang up bills for $16,647.36. However, Miss Siliski deposited $6,828.86. Apparently, that was okay with Mr. Bradford G.Y. Carney. Account balance: negative $100,846.35. On December 1, 2011, Dr. Catherine Killeen, child custody scam, testifies under oath, and the non-penalty, for the insane amount of perjury. In the fifth straight month of $0.00 of payments towards her legal bills, Miss Siliski, with zero income, musters enough wherewithal to pay the full $25. Or, was this a holiday gift card? In December 2011, Miss Siliski paid $25, yet Mr. Carney rang up bills for $9,498.65. However, Miss Siliski deposited $5,268. Apparently, that was okay with Mr. Carney. Account balance: negative $110,345. Miss Siliski deposited $89,002.71. Apparently, that was okay with Mr. Carney. These two accounts are also just a teaser. This may count as the tip of only one needle. Also not included in these numbers: 1. $1,475 per month from renting her father's home. Refused to provide account. 2. Annie Vatour, business generated over $11,000 in profits. Refused to provide account. 3. Unemployment compensation. Refused to provide account. 4. 5. These keep going. Note: many people were conned to ignore subpoenas they received from Mr. Stengel. As just one example, Cheryl McCann paid Miss Siliski in excess of $10,000 for her and her two daughters to go on the France trip. Ms. McCann returned the subpoena with some information. However, the specific information regarding any monies to Miss Silisky was ignored. Ms. McCann is an accountant. Note, these are only two of Miss Silisky's several accounts, many of which we have, many we don't, that we know about. Then there are always the many you don't know exist. Furthermore, Miss Silisky also worked at Farmers and Merchants Bank in 2010. Unable to locate that account, as that money too vanished. In time you will learn and see $47,000 vanish before your very eyes, along with in excess of $200,000. Even thousands vanished out of the charitable organization's account. Miss Silisky left part of that trail. End of 2011, balance is negative $110,345. It should be noted, what is really astounding are the line items which make up these bills. Surely, Bradford G.Y. Carney or the entire firm, Royston, Mueller, McLean and Reed, LLP, have other accounts resembling what is being witnessed. After all, they combined have over a century of legal work they can reference. We eagerly await your responses. Plural. Surely there are many of these, each year. Just grab one. One where a client professing zero income, then validated by the filings of the law firm, where their firm's accounts are allowed to be open-ended, like this. Meanwhile, the new year looks to be even more exciting. Don't you agree, Mr. Carney? I think Mr. Carney is too excited to speak. Almost forgot. The opposing side has a prenuptial agreement, which states the firm's client gets nothing. The firm did not contest the prenuptial. After Miss Silisky's January 18, 2011 payment of $5,000, Miss Silisky in almost a full year since, has paid only $2,994.61, with an account balance of negative $110,345. It appears Miss Silisky's payments would not even cover the interest on the balance. In fact, if the $5,000 check from Aunt Janet on June 15, 2011 for legal fees is added into the equation, as it should be, Miss Silisky has not paid $2,994.61. Instead, she pocketed the difference, $2,005.39. Obviously, Mr. Bradford G.Y. Carney and the entire law firm, Royston, Mueller, McLean and Reed, LLP, are completely fine with this arrangement. Aunt Janet's $5,000 check for legal services landed in Miss Silisky's IRA. Regardless of how you slice this, at least in 2011, and after January 18, 2011, it appears Mr. Bradford G.Y. Carney's business is generating a positive cash flow for Miss Silisky, to the tune of $2,005.39. In January 2012, Miss Silisky paid $0.00, yet Mr. Carney rang up bills for $7,382.55. However, Miss Silisky deposited $6,638.81. Apparently, that was okay with Mr. Carney. Account balance, negative $117,727.55. In February 2012, Miss Silisky only paid $500, yet Mr. Carney rang up bills for $4,680.95. However, Miss Silisky deposited $15,211.23. Apparently, that was okay with Mr. Carney, as well. Account balance negative $121,908.50. In March 2012, Miss Silisky paid $0.00, yet Mr. Carney rang up bills for $3,567.90. However, Miss Silisky deposited $6,747.19. Apparently, that was okay with Mr. Carney. Account balance, negative $125,476.40. In April 2012, Miss Silisky only paid $250, yet Mr. Carney rang up bills for $3,456.40. However, Miss Silisky deposited $15,546.13. Apparently, that was okay. With Mr. Bradford G.Y. Carney. Account balance, negative $128,682.80. In May 2012, Miss Silisky only paid $650, yet Mr. Carney rang up bills for $4,841.10. However, Miss Silisky deposited $14,040.40. Apparently, that was okay with Mr. Bradford G.Y. Carney. Account balance, negative $132,873.90. However, Miss Silisky deposited, from January through May 2012, $58,183.76, while paying only $1,400 towards her legal bills. Apparently, that was okay with Mr. Carney. Note, sworn filing of statement also went to Judge Enza, as Mr. Stengel inundated Judge This Judice Enza and the others with loads of evidence like this and much more. In yet another scam, the child custody scam, within that scam sits another scam called the child support scam. In order to figure out child support, Miss Silisky provided yet another sworn statement through Mr. Carney, where she swears on May 1, 2012, her gross income is $2,418 per month. Yet her luxury 3-bedroom apartment in a gated community alone costs over $1,875 per month. Net. Ms. Silisky's reported gross of $2,418 would not even cover her apartment. Note, let's not forget the sworn 2 expenses exceeding $9,700 per month. We went from 0 income statement filings, plural, December 22, 2010, and March 21, 2011. 1 year and 6 weeks later, we watch it increase to $2,418 gross.
Does anyone have anything they can donate to Miss Silisky? This victim needs help.
A glance at the deposits in the prior month and the month of May 2012 tells a much different story. This does not include all the other sources of income listed in red in the 2011 sheet we reviewed. Yet, Mr. Bradford G.Y. Carney filed this as well. With this latest fraudulent income statement, $2,418 gross monthly income, sitting in the middle of only 2 accounts, with surrounding deposits in the amounts of $15,546.13 and $14,040.40. Apparently, the subpoenas are not so irrelevant. In June 2012, Miss Silisky only paid $350, yet Mr. Carney rang up bills for $1,542.15. Account balance, negative $134,066.05. Miss Silisky filing 0 income statements, and Mr. Stengel has a prenuptial agreement, where Miss Silisky gets only what she came in with, almost nothing. Neither Miss Silisky or Mr. Bradford G.Y. Carney contested the prenuptial agreement. How is Mr. Carney planning on getting paid? In July 2012, Miss Silisky paid $0.00, yet Mr. Carney rang up bills for $26,112.15. Account balance, negative $160,178.20. In August 2012, Miss Silisky only paid $600, yet Mr. Carney rang up bills for $1,575. Account balance, negative $161,153.20. A quick look at what was provided to Mr. Stengel ends in August 2012, even though the case continues years beyond that date. From January 2012 through August 2012, Miss Silisky and Mr. Carney generated $53,158.20 of additional bills. This, while accepting a mere $2,350 in total payments. The outstanding balance as of August 2012 is negative $161,153.20. We must update the earlier request made to Mr. Bradford G. Y. Carney and Royston, Mueller, McLean and Reed, LLP, to now provide clients with the same scenario and where the extended credit exceeds $161,000. Surely Judge this Cienza has many cases she presided over that she can point to with the same scenario where she considered this reasonable. Just find one. In fact, as a courtesy and to make her homework assignment easier, we will include any cases she handled when she was an attorney as well. The entire United States of America eagerly awaits her response. In December 2010 and through all of 2011, Ms. Zaleski's payment rate is 12.22% of her bills generated. From January 2012 through August 2012, Ms. Zaleski's payment rate is 4.42% of her bills generated. Mr. Stengel could not question the bills, nor was he ever provided all of the bills they demanded he pay. You can try your own test. When your plumber comes and completes the work, or your auto mechanic for that matter, tell him you are just going to pay 4.42% of his bill. Then watch his reaction. Is that the reaction of someone who considers your offer reasonable? Now, let's switch sides. You only pay your plumber or auto mechanic 4.42% of his bill. However, you need their services again. They are happy to do more work for you. If you were their boss, would you consider that reasonable? And again, you only paid them 4.42% of their bill. However, you need their services again. They are happy to do more work for you. If you were their boss, you would be fired. Just 1 month before Mr. Feder was asked to testify as an expert, Mr. Carney, on October the 25th, 2012, nearly 2 years after he began, stated,
"Have you requested attorney's fees in that divorce case?"
Well in excess of $150,000, Your Honor. The biggest divorce matter I've ever been involved in as a lawyer because of Mr. Stengel's conduct.
Mr. Carney began on December the 15th, 2010. Almost 2 years later, October the 25th, 2012. Note, really, the biggest case ever, designed from a case with an uncontested prenuptial agreement, where Mr. Carney's client gets nothing. This is simply Mr. Carney's prenuptial workaround scam. Besides the fact, Mr. Carney never got any judgment against Miss Zaleski for any fees allegedly owed. Oops. Sorry, Mr. Carney. Was that to be a secret? How is Mr. Carney planning on getting paid? Is Mr. Carney confused about the prenuptial agreement? Let's listen on October the 25th, 2012.
Most of the marital property, frankly, is not marital property because there's a prenup. Most of the marital property, frankly, is not marital property because there's a prenup.
Most marital property is not marital property. Note, dear Mr. Bradford G. Y. Carney, your doublespeak may confuse some people. Either it's marital property, or it's not. Allow me to translate precisely what Mr. Carney is saying. Mr. Carney was always fully aware of the prenup, and never contested it. However, contrary to what Mr. Carney just said, the amount of fraud bills generated, by ignoring what Mr. Carney just confessed to, is astounding. Surely Judge this Cienza, who went through all the bills, line by line, and went through all the volumes in this case, would easily figure out Mr. Carney's obvious scams. Unless she herself is a participant in the scams. So, we know Mr. Carney was well aware of the prenuptial agreement and did not contest it. Although Miss Zaleski and Mr. Carney did not contest the prenup, Mr. Carney's bills are loaded with line items which reflect actions of one contesting the prenuptial agreement. Besides, this video was also provided, along with many others containing confessions by Miss Zaleski.
Oh my God, imagine your possibility of building something with someone.
How can I see into this?
Don't see how you're taking away. I told you, and I will tell you again. I have said to you, put it all in another name. Write a document and I'll sign it. For me, it is that's right. It's like a mirror. If you don't listen, you're dead. You're dead. Listen. Excuse me. If you're not listening. hopefully, because I realize you're on the floor, you're on the fucking floor, you're an asshole! On the floor, you fucking asshole, I hate you! I don't want to be your goddamn floor! You're the fucking piece of shit! You are not your floor! Here it is.
What are you gonna do? What are you doing? Suze, what are you doing?
She's going psycho.
I'm sorry, guys.
She's going psycho.
I'm sorry, guys.
She's going psycho. She's going psycho.
I'm sorry, guys.
She's going psycho.
Having been provided that where, even without the prenup, Miss Silisky confesses nothing is hers, so she will sign away what's not hers. With the many videos provided, including the earlier viewed 5-second video clip of a violent act by Miss Silisky, and caught on tape, and Mr. Carney's line item billed $75 to watch it. We now listen to Judge Judith Cienza on this very topic that same day. Decision Day, September the 18th, 2013. Reminder. Like them all, she is disparaging Mr. Stengel. This is simply a matter of just how ridiculous can they get? And sound.
Invoice number 45943, dated September 7th of 2011, contains an entry for watching the Truth About Susan video. There should be no video. No one should be watching the video.
However, billing $75 for a 5-second clip is a-okay. Besides, reality, facts, and hundreds of provided clips from inside the home, over several months, is not permitted. Apparently, it interferes with their business model. Now let's resume with Mr. Carney's statements on October the 25th, 2012. We will listen to the extended version.
Most of the marital property, frankly, is not marital property because there's a prenup. This is his second marriage. You heard from his first wife. You know, the marital home is excluded from the equation according to the prenup. There's no mortgage on the marital home.
Did someone ask, how is Mr. Carney planning on getting paid? There are 2 out of 3 clues. 1. Mr. Carney is well aware the prenuptial covers and protects the children's family home. 2. The children's family home is paid off. To a vicious animal, that's a juicy T-bone steak.
Biggest divorce matter I've ever been involved in as a lawyer because of Mr. Stengel's conduct.
Definition of Mr. Stengel's conduct. A father who refuses to allow a meticulously documented psychotic group use and abuse his children and communities to line their pockets. Note, or is Mr. Carney upset his usual scam and move on routine ran into a snag? An over 5-year-long and still going snag. A snag called, "You Can't Play God." Besides, allowing the devil to play God would cause mass confusion. Mr. Carney's statements as an officer of the court were made in 2012. Wait until you hear what's been said and done since. Note, Mr. Feder testifies as an expert 2 years after the fraud bidding began and 1 month after what turns out to be Mr. Carney confessing his designed frauds and scams as he created what he himself called
Biggest divorce matter I've ever been involved in as a lawyer because of Mr. Stengel's conduct.
Why would anyone need to go beyond the first couple of weeks in Mr. Carney's bills? Maybe Mr. Feder needed to be asked, for what outcome is he opining? By opining, he is swearing it's normal. That's what the expert is really saying, or swearing to. What's going on here is kosher. Let's hear from Mr. Feder.
And as a consequence of your review of those bills, do you have an opinion within a reasonable degree of professional legal certainty as to whether or not they are fair, reasonable, and necessary?
I believe they were fair, reasonable, and necessary.
Dear Mr. Feder, that fraudulent expert testimony was provided in Judith Cienza's courtroom on November the 30th, 2012. Now, let's tie a nice little frog bow around this obvious scam, which they were all aware began on day 1, as they ran their fraud scams, racketeering, extortion, child predatory acts, brainwashing, abuses, barratry, and attempts to silence critics for several years. Strategic lawsuit against public participation appears to be custom-made for this group. That's the summary of the short list. Just 4 days before Mr. Feder's sworn testimony, and on November the 26th, 2012, as Mr. Stengel yet again warns them of his intentions, as Judge Judith Enza presided over this.
Sorry. That's what Mr. Lazaro suggested, yes.
Okay, are you abandoning that argument?
No, I'm not abandoning it partially, but it's not all that. It's OCD, and so therefore, I was upset because of all these things that were occurring to my children, right? So, that coupled with OCD, I was just putting evidence together. That's what I was doing.
In short, we have this entire group claiming Mr. Stengel is mentally ill for documenting their crimes against his children and the public. Mr. Robert Wayne Lazaro, Mr. Stengel's alleged attorney, and a full member of their group, insisted on that strategy. Yet Mr. Lazaro never questioned any of their outrageous bills. Just 8 pages later, Judge Enza plays Miss Sileski's attorney. Mr. Stengel sets her straight with reality.
Your Honor, it's all been snowballed. The whole entire thing has been created out of thin air and fabricated and then snowballed and involving all these people that they don't even know that they've been involved. They don't even have any idea what Susie has done to these people and involved their families. And not only, she's created expenses for the Osprey because you can come with an attorney, Your Honor. I mean, it doesn't end. This started, and it hasn't stopped because she won't stop. She just won't stop.
Well, I think she would say that you won't stop.
Well, I can prove, but that's the difference.
That's where we are with this.
Right, but that's the difference. I have evidence, and she doesn't.
Well, I think she would say that you won't stop.
Well, I can prove, but that's the difference.
That's where we are with this.
Right, but that's the difference. I have evidence, and she doesn't. 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 I have evidence, and she doesn't.
If you haven't seen and heard enough, Judge Judith Enza, in a 100% illegal act, refused Mr. Stengel question Mr. Carney regarding his outrageous bills, which Mr. Stengel is being demanded to pay. Judge Judith Enza also refused Mr. Stengel question Dr. Catherine Killeen. Mr. Stengel didn't bother asking to question Leon W. Berg's fraud bills after that circus. Let's take a look.
I have a question for Your Honor, if you don't mind. In relation to Mr. Carney's bills, am I able to ask him questions in regards to his bills?
No.
No?
That 100% illegal act by Judge Judith Enza is clear. Let's look at the level and depth of insanity required to provide that answer. You can't ask questions about a bill which you are being demanded to pay. Really. Besides, in the mind of psychosis, where in reality could that ever apply? Can you ask a restaurant, your mechanic, the hotel, the dollar store, the supermarket? Yes, 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 yes. But hundreds of thousands of dollars in obvious fraud bills placed with conspiracy of their very frauds? No. But just within the area of psychosis. However, 4 days later, on November the 30th, 2012, and after Mr. Fedder's sworn expert testimony, Mr. Bradford G.Y. Carney confesses directly to Judge Judith Enza with this statement.
Because as Mr. Fedder said, to ferret out the lie, you've got to do more work. And the more work I did, the more frustrating it became because I just kept coming up empty.
However, just 3 pages prior to Mr. Carney's confession of having nothing to show for his $200,000 of obvious counterfeit orders and fraud bills, Mr. Carney clarifies how he plans on getting all of his counterfeit orders and fraud bills paid.
They may say it's encumbered, and if I have to move to set it aside, I will do so, and I think I will be successful in doing just that.
Mr. Bradford G.Y. Carney has scammed from day one with 3 things in mind. 1. Bypass the prenuptial agreement. 2. By counterfeiting orders to generate fraudulent bills. 3. Steal Mr. Stengel and the children's family home. Note, even Mr. Leon W. Berg, the alleged best interest attorney for the children, was filing things to force the sale of his minor client's family home. And keeps trying. Dr. Catherine Killeen also joined forces to steal the children's family home. And of course, Ms. Susan Sileski as well, who told Alex she would buy it at auction, then sell the family home for a profit. All collectively involved in their scams from day one.
West's Annotated Code of Maryland. Criminal Law. Title 8. Fraud and Related Crimes. Subtitle 6. Counterfeiting and Related Crimes. Counterfeiting of orders for money or goods. Order for money or goods defined. A. In this section, order for money or goods means any writing, ordering, or requesting for the payment of money or the delivery of goods. Prohibited. B. A person may not 1. With intent to defraud another, cause or procure to be counterfeited, or willingly aid or assist in counterfeiting an order, for money or goods. 2. With intent to defraud another, issue, publish, or pass a counterfeit order for money or goods, if the person knows it was counterfeited. Or, 3. Knowingly and fraudulently obtain money or goods, by means of a counterfeit order for money or goods. Penalty. C. A person who violates this section is guilty of a felony, and on conviction is subject to imprisonment for not less than 2 years, and not exceeding 10 years.
Also committing fraud upon the federal court, as well. That illegal act by Judge Thisju Dispenza, just 4 days earlier, pretty much opens the already open floodgates, as you already learned, have obviously been opened from day one. Now, Mr. Carney, and the others demanding Mr. Stengel pay their fraud bills, opens it even wider. 4 days later, and the same day as Mr. Fedder's sworn expert testimony, on November the 30th, 2012, were closing arguments. Judicial rules state the judge has 60 days to render a decision. However, none of them follow rules or laws. Also evidenced by it taking Judge Thisju Dispenza nearly 10 months to reverse engineer all the realities, facts, evidence and truths on September the 18th, 2013. The very day, Judge Dispenza called Miss Siliski a liar, lies to police, files multiple false financial statements, yet Judge Thisju Dispenza comes up with this.
I went through the bills. I went through them line by line. I studied the descriptions of the work performed, and I considered the rates charged. Part of that review, frankly, was with an eye to determining who was actually driving the litigation. And of course, for that, I only have the pleadings filed and the descriptions delineated in the bills themselves. I do find the hourly rates charged to be fair. I find the time allotted for the tasks performed reasonable. I find that of the almost $200,000 in legal bills, much is attributable to inappropriate actions on the part of Mr. Stengel.
Yes, both on the same day, September the 18th, 2013. Having just heard from pages 192 to 193, way back on pages 16 to 17, you heard it right. Listen once more.
Mr. Rudo, I already know that Ms. Stengel hasn't always been honest. I know that. I know she lied to the police officer because she had Mr. Stengel's phone when she said she didn't. So I know that. And I didn't escape my notice that there were several discrepancies in the financial statements. In fact, in that hearing we had that lasted several days, it was like every day. Actually, I would get a before lunch and after lunch amendment. So, I mean...
Both on the same day, which lends itself to this.
Mr. Stengel is the kind of person that I would have to be very careful with my words.
Judge Thisju Dispenza herself confirms Miss Siliski is a thief, will then lie to police about the stolen property, file false financial statements, then when caught, changes the financial statement to a new, false version, then repeated that many times until. Sit down for this one. Judge Thisju Dispenza eventually told Miss Siliski to forget about it.
I find that of the almost $200,000 in legal bills, much is attributable to inappropriate actions on the part of Mr. Stengel.
Now, where else have we heard that exact statement? 11 months earlier, on October the 25th, 2012. Let's listen again.
Biggest divorce matter I've ever been involved in as a lawyer because of Mr. Stengel's conduct.
I find that of the almost $200,000 in legal bills, much is attributable to inappropriate actions on the part of Mr. Stengel.
Biggest divorce matter I've ever been involved in as a lawyer because of Mr. Stengel's conduct.
Really? Because of that very same trial, to extend the already bogus protective order, as Judge Mickey Norman is hoodwinked, conned, and played like a fool, comes this confession, which contains many confessions, and implicates their entire crime ring in their collective frauds. Let's take a look.
Okay. And did Dr. Colleen say anything during the course of her testimony that puts you in reasonable fear of bodily injury?
She did.
What did she say under oath?
She said that she thought he was a danger to himself and others.
We will replay that, but first, let's dissect some fraud. Note, you may have noticed Miss Siliski and her crocodile tears. If not, now that you know, you will. 1. Miss Siliski has been filing fraudulent emergency protective orders, claiming imminent danger, since November the 29th, 2010. 2. 8 days later, on December the 7th, 2010, comes the protective order trial. Miss Siliski loses the case. Note, on December the 15th, 2010, Mr. Bradford G. Y. Carney gets involved. Very involved. On January the 6th, 2011, Leon W. Berg, the alleged best interest attorney, signs on. On January the 7th, 2011, Dr. Catherine Killeen signs on. 3. 10 months later, on October the 15th, 2011, Miss Siliski, in cooperation with Bradford G. Y. Carney, Leon W. Berg, Dr. Catherine Killeen, Robert Wayne Lazaro, and others, while covertly involving others, in a staged scam, targets Boyce Latin School of Maryland, simply by forwarding the same false allegations and manufacturing new false claims. This done, using the school's annual Fall Fest event as their stage, in a pre-designed covert operation, to manipulate Boyce Latin School, their headmaster, Christopher Post, their teachers, staff, parents, such as Alison Meister Friedman. 4. 1 month to the day later, on November the 15th, 2011, Miss Siliski, in cooperation with Bradford G. Y. Carney, Leon W. Berg, Dr. Catherine Killeen, Robert Wayne Lazaro, and others, files her second fraudulent emergency protective order, by forwarding the same false allegations and manufacturing new false claims, imminent fear. 5. 1 week later, on November the 23rd, 2011, comes the second fraudulent protective order trial, where Miss Siliski, in cooperation with Bradford G. Y. Carney, as confessed in a later trial, alters the evidence provided to the court, now known as the altered evidence trial. Alison Meister Friedman is manipulated to come to court and commit multiple counts of perjury. 6 days later, Mr. Stengel provides a package containing evidence of the altered evidence used at trial. The package contained both the originals and what was provided by Miss Siliski and Mr. Bradford G. Y. Carney. This package went to Judge Leo Ryan, who presided over the case. Bradford G. Y. Carney, Leon W. Berg, Dr. Catherine Killeen, Robert Wayne Lazaro, and the Maryland State's Attorney, Scott D. Schellenberger, where Mr. Stengel was told to come back when he has something more concrete. 7. 2 days later, on December the 1st, 2011, comes the child custody hearing, where Dr. Catherine Killeen, with foreknowledge and malice, fraudulently testifies under oath, and the severe penalty of perjury, in cooperation with Leon W. Berg, to the complete opposite of all evidence to date. Note, perjury, when it alters the outcome, each and every count, becomes a solid, criminal act, and is no longer a misdemeanor. 8. With all of the fear and claimed emergency protection needed, spanning almost 2 years, now, on October the 25th, 2012, in cooperation with Bradford G. Y. Carney states, it was Dr. Catherine Killeen's testimony that put her in reasonable fear of bodily harm. Simply put, since Miss Siliski doesn't have her own experiences of her many claimed abuses to rely on, she is relying on testimony provided by Dr. Catherine Killeen under oath, as Mr. Carney so kindly reminded us. Surely, abused people don't forget the specifics, let alone the entire event, and in this case, several dozens of events, as sworn to by Miss Siliski, under oath, and the penalty of perjury, and suborned by Mr. Bradford G. Y. Carney, from Royston, Mueller, McLean and Reed, LLP. Even if we take a ride on the delusional trolley, and there could be a 1% chance of this not being yet another 100% fraudulent scam, the originating fear claim Team Carney and Siliski are referring to was on December the 1st, 2011. That's after 2 completed protective order filings, both loaded with dozens of claims of abuses, followed by sworn testimony where even more allegations of abuses were added. However, when we get off the delusional trolley, Mr. Bradford G.Y. Carney and Miss Silisky just confirmed it was on December the 1st, 2011, and Dr. Catherine Killeen's testimony that put her in reasonable fear of bodily harm. At best, Mr. Carney, as an officer of the court, is saying reasonable fear. Maybe Mr. Carney can explain which fear he is aware of that would be considered reasonable. That makes the reasonable bullshit. Nothing more than an attempt to hoodwink the court. Because either you are in fear or you are not. You can't be placed in reasonable fear. Even if this unconscionable's words are accurate, and ignore the obvious facts, all of Dr. Catherine Killeen's sworn statements provided was knowingly false, and we put all that aside, it's still a year after 2 protective order filings and sworn testimony provided at both legal trials. Or was all of the previous emergency protective order filings and sworn testimony in preparation of Dr. Catherine Killeen's upcoming testimony? How obvious is Dr. Catherine Killeen's sworn testimony on December the 1st, 2011, regarding Mr. Stengel being a danger and a risk, completely fraudulent? How obvious was her testimony provided with malice, with the intent and foreknowledge it was in the minor children's worst interest? How obvious is it Mr. Leon W. Berg's intent was and is against his minor client's best interests, and done so knowingly and with foreknowledge, while suborning Dr. Killeen's pre-planned fraudulent testimony? How obvious is it Bradford G.Y. Carney, Miss Silisky, Robert Wayne Lazaro, and Judge This Judith Enza were and still are not only aware, but participated in the frauds against the children and their communities? You mean, besides the small missing details called evidence? This is how. On December the 1st, 2011, Dr. Catherine Killeen provided sworn expert testimony on page number 23 regarding her methodology.
Well, the methodology that I used in this case is standard acceptable methodology when one is conducting a custody evaluation. And the guidelines of the American Psychological Association
This sworn testimony on page number 34 relates to Mr. Stengel allegedly being such a danger he requires therapeutic supervision. But really the alienation game. We will listen to the key portion for this fraud exhibit. Such a danger, the children should not be able to be with Mr. Stengel overnight. We will listen to it twice, so it sinks in.
That person should also have open communication with the person that's doing the supervised visitation. Because I think these kids are severely at risk. Severely. That person should also have open communication with the person that's doing the supervised visitation. Because I think these kids are severely at risk. Severely.
On January the 7th, 2011, Dr. Catherine Killeen began, hired to do impartial, independent, extensive psychological tests on both parents, as well as child custody evaluations. For the purposes of this presentation, we will focus on one of Dr. Killeen's contractual obligations, shown on pages number 1 to number 2, and noted as reference number 4.
4. There are some situations in which I am legally obligated to release information and take action to protect others from harm, even if I have to reveal information that I obtained during the evaluation. For example, if I believe that a child or vulnerable adult is being physically or emotionally abused, I must file a report with the appropriate state agency. Furthermore, if I believe that you are threatening serious bodily harm to another, I am required to take protective actions. These actions may include notifying the potential victim, contacting the police, seeking hospitalization, and/or developing some other protective plan. If you threaten to harm yourself, I may be obligated to seek hospitalization.
That person should also have open communication with the person that's doing the supervised visitation. Because I think these kids are severely at risk. Severely.
Note, apparently, the children are at such risk, severely at risk, yet Dr. Catherine Killeen waited 11 months, and until she got into the courtroom, on December the 1st, 2011, to make any mention whatsoever in that regard? Really? Not a call, and email, letter, motion, as they sure filed many of those. Not a word spoken, to anyone, anywhere, ever. Until her sworn testimony, provided under oath, and the penalty of perjury, extracted by Leon W. Berg. Her own contract uses the words
obligated, must,
and
required.
However, Dr. Catherine Killeen and Leon W. Berg, in fact, did the opposite. Alex reported being physically abused many times, even noted in the visitation reports, and twice reported it to his school, Boyce Latin School of Maryland. Hoodwinked to not call the authorities by state law, rather called Leon W. Berg, who shut it down. Reality. The kids were at risk, severely at risk. But not until after Dr. Catherine Killeen generated nearly $50,000 of counterfeit orders and fraud bills. A mere 6 weeks after Dr. Catherine Killeen's knowingly fraudulent testimony, Miss Silisky, out of the blue, files her first fraudulent criminal filing, in cooperation with Mr. Carney, Leon W. Berg, Dr. Catherine Killeen, Robert Wayne Lazaro, and others, where the state's attorney, Scott D. Schellenberger, is more than happy to criminally charge Mr. Stengel, even though the main allegation was not even possible. The criminal trial was set for March the 19th, 2012. Mr. Stengel was not properly served. Mr. Stengel had to go to the courthouse that day, March the 19th, 2012, to advise the court, and have it rescheduled. The court served Mr. Stengel while he was there. Miss Silisky comes to court. With Miss Silisky was none other than Mr. Bradford G. Y. Carney, who was apparently going to assist the state prosecutor to falsely incarcerate Mr. Stengel. Mr. Carney was extremely angered that the case needed to be postponed due to lack of proper service. Although this is a completely different issue than the divorce case, and a different case number, Mr. Carney added 0.50 hours for $187.50 for his fraudulent and criminal actions, which he added in the divorce case billing. Apparently, this too was necessary and reasonable, according to Mr. Stephen Feder and Judge This Judith Cienza. Invoice date, April the 4th, 2012. Balance forward as of invoice dated March the 5th, 2012. Note: Welcome to the shell game. Account balance, negative $121,908.50. Payments received since last invoice, $0.00. On March the 19th, 2012, Mr. Carney's bill notes.
BGC. Appear with Susie before Judge Steve Wyman, at Towson District Court. Defendant was served and case postponed.
Billed 0.50 hours for $187.50.
Read email from Susie regarding her conversation with Maya about lying to her father. Draft email to Dr. Killeen and Leon Berg.
Note: the
Maya lying to her father
allegation is dealt with in another presentation. For this presentation, we note the entries regarding Leon Berg and Dr. Killeen, and of course, their criminal scam being billed in the divorce case. Is that also okay, Mr. Glenn Grossman? On March the 22nd, 2012, Mr. Carney's bill notes.
BGC. Draft letter to Bob Lazaro regarding GoDaddy subpoena, response, and postponement of criminal case on March 19, 2012. Draft letter to Judge Enzer to advise court of March 19, 2012. Postponement of criminal charges by M. Stengel, and possible effect on remaining 2 circuit court trial dates.
Billed 0.80 hours for $300. Note: keeping Judge This Judith Enzer in the loop.
Is that normal?
No. Besides, nothing is normal about this group. 1. You call civil assignment for scheduling, not a judge. 2. However, in this instance, you would not call either, since the criminal sham case that was postponed just occurred, and a new date has not been provided yet. Therefore, how can it conflict with anything else? 3. Furthermore, if the court dates for the criminal sham case conflict with dates already set with Judge This Enzer's court dates, you adjust the dates not set, not the ones already set. 4. However, the goal is to somehow, anyhow, come hell or high water, get Mr. Stengel in prison, so they can more easily steal his and the children's family home, and discredit Mr. Stengel's documenting their insane amount of crimes. 5. Isn't that correct, Judge This Judith Cienza? 6. Therefore, what you are reading is Mr. Carney briefing his crime team partner, Judge This Judith Cienza. 7. Then asking how to best proceed. Let's take note of all the entries regarding Mr. Berg and Dr. Killeen.
1. Return L. Berg's call. 2. Conference call with Leon and Bob. 3. Sign and email to Bob, Leon. 4. Call from L. Berg. 5. Draft email to Leon, and Dr. Killeen. 6. Draft email to Dr. Killeen and Leon Berg. 7. Read Leon's email to me of today.
Keep all of that in mind, for when we look at the spread the fraud sheets. A quick note regarding Enza's irrelevant subpoenas comment, and it's Mr. Stengel's doing, like everything else. Well, again, it's the complete opposite. You may notice all the GoDaddy entries they kept billing for. We ignored it for this presentation, however. On page number 2, Mr. Carney's bill notes, March the 29th, 2012.
BGC draft letter to K.R. Willis of GoDaddy enclosing check for $447.71. Total expenses incurred. $15.40.
Billed 0.10 hour, $437.50. Note 1. Apparently, Miss Silisky doesn't pay their expenses laid out, as per their undated retainer agreement. 2. You will notice, it's not listed in the expenses area. Apparently, this is one of the reasons for that strange and curious clause in their agreement. 8a.
Defray.
This may be one of those
types of services
they provide to their clients.
Total expenses incurred. $15.40.
Really? That should clear up their strange and curious clause. Reality, more fraud. 3. You may want to sit for this one. 3a. The GoDaddy information can be gotten for free, online. 3b. It gets worse. That very information was provided to Miss Silisky and Mr. Carney by Mr. Stengel many months earlier. 3c. It gets even worse than that. Further evidence of Mr. Stengel having already provided all of that information, Miss Silisky and Mr. Bradford G.Y. Carney added it all in a filing or motion several months earlier, basically giving it back to Mr. Stengel and the courts, which is already in Judge This Judith Enza's position. And always remember, we look at the spread the fraud sheets bills. Page number 101 of 130. Referenced as number 1, Mr. Stengel documents, first criminal filing, trial date, postponed. Mr. Stengel was never served. Mr. Carney is present and visibly angered. Mr. Stengel isn't going to prison that day. Very distraught over the numerous amount of crimes documented by Mr. Stengel. Criminal allegations, all false. See, presentation. Referenced as number 2, Mr. Stengel documents, anyone seen Mr. Leon W. Berg? His client's father may falsely go to jail. Note, number 3 and number 4 we already reviewed in the actual bill. Leon W. Berg and Dr. Catherine Killeen's columns are empty. Although we know they are in action. Killeen's column is empty, for a good reason. Dr. Catherine Killeen has not been cross-examined from her fraudulent December 1, 2011 testimony, which Mr. Leon W. Berg suborned. At the time of these entries, Dr. Killeen's cross-examination is scheduled for May 2, 2012 and May 3, 2012. Therefore, Dr. Catherine Killeen is technically still on the stand. Surely, Judge This Judith Enza can figure that out. Let's back up one page, so the dates will leave no questions. Spread the fraud sheets, page number 100 of 130. Mr. Stengel documents the following. Restraining order trial. Exposing crimes via website is bad. Email is bad. Speech, Lazaro, double agent, surrenders. You will notice yet more entries regarding Mr. Leon W. Berg. Again, his column and Dr. Catherine Killeen's column are both empty. Also take note of more GoDaddy entries. I hope you were provided some insight with their first fraudulent criminal case scam they all ran, including the Maryland State's attorney and the corrupt and child predator-friendly Scott D. Schellenberger. Which brings us back to October 25, 2012, and the lifetime role-playing of victim, but really they are the predators, now documented as such. Hopefully, you enjoyed that extremely tiny sample. For a documented list of some of their crimes, simply go to the Baltimore County, Maryland court records and look at Mr. Stengel's extensive list, which began on November 29, 2010, and hasn't stopped. They sell those actions as Mr. Stengel's wrongdoings, when in reality, the extensive list is nothing more than evidence of their crimes, at taxpayer expense. Hoodwinking, conning, and abusing hundreds, to abuse children and communities, while pocketing money, to buy gifts, toys, even send their own kids to college, with your money.
Did Dr. Colleen say anything during the course of her testimony that put you in reasonable fear of bodily injury?
She did.
What did she say under oath?
She said that she thought he was a danger to himself and others. She said that she thought he was a danger to himself and others. She said that she thought he was a danger to himself and others.
I find that of the almost $200,000 in legal bills, much is attributable to inappropriate actions on the part of Mr. Stengel.
Really? Because a tree stump could figure out it's 100% complete bullshit.
You screwed with the wrong dad.
You screwed with the wrong dad.
Rate it? Rate what? This bunch of psychotic, evil, unconscionable nut jobs? Really? Can I go now?
Ridiculous. Can I go now? He's right. It's all bullshit.
I find that of the almost $200,000 in legal bills, much is attributable to inappropriate actions on the part of Mr. Stengel.
It wouldn't be fair if we didn't take special notice of just some of her delusion, just in one of her statements.
Part of that review, frankly, was with an eye to determining who was actually driving the litigation. And of course, for that, I only have the pleadings filed and the descriptions delineated in the bills themselves. For that, I only have the pleadings filed and the descriptions delineated in the bills themselves.
Really? Only? Judge this Judith Cienza only has the insane number of fraudulent sworn filings, sworn orders, sworn motions, sworn testimony, and the descriptions in their very own fraud bills. To make all of their actions even more ridiculous, all mentioned contradict each other, and often there are contradictions within the same filing, or motion, or even the same transcript page. What would be to a 5-year-old evidence of their crimes, to this villain, is evidence of facts and law. Evidence, mind you, which cannot be questioned. Evidence where the author himself confessed to constantly coming up empty. Having spent loads of time investigating nonsense, it would appear Mr. Carney was ongoingly confused, since he kept investigating. Obviously, Mr. Carney kept coming up empty. That's what happens when you fish in a dry cement pond. Mr. Carney and the others can clearly see the pond is empty and dry. Yet Mr. Carney kept fishing. Mr. Carney kept fishing for years. Someone should tell Mr. Carney the pond will first require some water. One who will Mr. Carney say was directing him? Miss Silisky? The one judge this Judith Enza herself said was a liar, and files multiple false financial statements, repeatedly to the same judge. 2. Mr. Carney confessing he kept coming up empty, would mean he has no evidence. 3. Mr. Carney confessed to constantly coming up empty, means his line items are for naught. 4. If Mr. Carney's line items are for naught, how would Judge this Judith Enza, 10 months after Mr. Carney's confession, use those very line items as evidence of fact? 5. How would Judge this Judith Enza find that the opposing counsel's confessed to repeated wasted efforts be Mr. Stengel's doing? 6. How would Judge this Judith Enza find that the opposing counsel's confessed to repeated wasted efforts be Mr. Stengel's responsibility? 7. If Mr. Carney spent so much time, yet kept coming up empty, how would that be necessary, in any way? 8. How many wasteful investigations is needed, before the billing becomes unreasonable? 9. Wouldn't doing work, yet not getting paid, yet continue to do work, and continue not getting paid, yet continue doing work, be the unreasonable, the sworn expert, Mr. Stephen Feder and Judge this Judith Enza, should be speaking about? Note, this numbering can go on for quite some time. At the very least, we have Judge this Judith Cienza confessing to using Bradford G.Y. Carney's descriptions in his bills as her chosen evidence in this case. At the same time, ignored all the confirmed, even confessed to evidence. Judge this Judith Cienza not only ignored the bank statements, she even ignored her own statements and her own outrage regarding 4 false financial statements, and confessing Miss Silisky, in so many words, is a serial perjurer. Judge this Judicienza fraudulently slams Mr. Stengel with judgments in favor of Dr. Catherine Killeen for $13,856. That is on top of the over $20,000, an insane amount already paid by Mr. Stengel. In favor of Mr. Leon W. Berg for $25,676. That is on top of the over $20,000, an insane amount already paid by Mr. Stengel. And multiple judgments in favor of Miss Silisky in the amounts of $636, $1,067, $3,565 for complete bullshit. And the infamous legal bills judgment in the amount of $135,000. Miss Silisky's judgments are in her name. Therefore, Miss Silisky owes Mr. Bradford G. Y. Carney and the law firm Royston, Mueller, McLean and Reed, LLP, in excess of $200,000. Yet Mr. Carney and Company have no judgment for any of that $200,000. How much has Miss Silisky paid towards her $65,000 portion and towards the $135,000 which she is responsible for to Mr. Carney and the firm? How many communications have there been since in regards to them requesting money from Miss Silisky? As you can clearly see, Mr. Carney did not provide Mr. Stengel with any more of his fraud bills after August 2012. We know, through August 2012, Miss Silisky paid only 4.42% of her legal bills. What happened after that date? Let's add another ingredient to this fraud stew. Just 3 days after Judge Thisenza's illegal and fraudulent act, not allowing Mr. Stengel to question Mr. Carney regarding his obvious fraud bills, comes this, on November the 29th, 2012.
Mr. Stengel, in this divorce proceeding, you were initially represented by another lawyer, correct?
Yes.
The name being?
Ellen Rosenberg.
And you discharged Ms. Rosenberg?
Well, she didn't represent me in the divorce, but yes.
Okay. And her bill has been paid in full?
Yes.
Matter of fact, you just recently were able to finish paying that off.
Yes.
Isn't that correct?
Like a week ago, 2 weeks ago.
Recall approximately how much you paid her?
In total, no. Maybe $5,000.
There is so many red flags on this page, however, we will focus only on the money. It's November the 29th, 2012, and Miss Silisky and Mr. Carney just now advises the court Miss Silisky hadn't even paid her first attorney from 2 years earlier, stating she paid Ms. Rosenberg. Well, Miss Silisky is not sure. Miss Silisky thinks she paid her $5,000. Let's take the $5,000 amount. That was not paid until 1 to 2 weeks earlier. Let's use November the 15th, 2012. On top of all of the overwhelming and obvious frauds and scams, we are now made aware all of Mr. Carney's actions were on top of knowing Miss Silisky hadn't even paid her attorney before hiring Mr. Carney. It's apparent that too was not a concern for Mr. Bradford G. Y. Carney, or Royston, Mueller, McLean and Reed, LLP. Really? We know Aunt Janet's $5,000 check on June the 15th, 2011 went into Miss Silisky's IRA. This also confirms that $5,000 did not go to her first attorney for the first fraudulent protective order on November the 29th, 2010. Meanwhile, Judge Thisenza is listening to this. What will Judge Thisenza do with this damning information?
In total, no. Maybe $5,000.
Well, excuse me 1 second, because your question, Mr. Carney, was, did somebody represent you in this divorce proceeding before I did?
Right.
And the answer was yes, but then this witness testified, but she didn't represent me in the divorce. So perhaps
maybe
he represented her with a protective order or some other litigation between these parties. But it doesn't...
Let me clarify.
How's that relevant to my issues?
Really? Allow us to answer your question. 1. That's not what Mr. Carney said. Mr. Carney made a statement, not a question. 2. How is it relevant to your issues? Dear Judge Thisenza, try this on 4 size. 2a. Your instant redirect focused tactic is not the first time. We have more. 2b. The testimony you steered off course was relevant to the financial issues. That's why you instantly redirected the conversation, which was damaging to your cause, to say the least. 2c. Your redirect topic was also complete bullshit. You said, perhaps, it was, blah, blah, blah. Really? 2d. You alienated the case via the specially assigned scam. Therefore you have all the files, and insane number of volumes. Let's bring the rest of the crime ring in, for the finale. Now where did they all go? To E, perhaps. Because, it's the very first thing in the first volume. Miss Zaleski's first fraudulent protective order scam, on November the 29th, 2010, which launched all of this, which, just in case you are trying to explain your level of insanity, it's the very reason all of this took place. Huh? Oh yay. You can play dumb all you want, however, the stench will never leave you. Does that answer your question? How is it relevant to your issues? If not, go with this. It's relevant, because your issues are clearly fraud, therefore, it in fact, is relevant to your issues. Normally, a contract or agreement denotes what will or must occur. However, this clearly denotes what will not occur. Like everything else, it's the 100% complete opposite. Selling delusion as reality, till now, has been very lucrative for this group.
6 months I've generated a French business and I already have income coming in. 6 months I've generated a French business and I already have income coming in.
Work?
You actually, yes, actually I do, you don't. Yes, I have always worked. You haven't worked in 3 years.
Unemployment checks.
Really? And you, when you collected unemployment, were you working?
You said I haven't worked in 3 years.
You haven't worked.
Can't have it both ways?
Did you work?
Can't have it both ways?
Did you work?
No.
Oh.
I was learning.
Let's listen to Judge Judith Enza, on November the 30th, 2012, talk to Mr. Rudo, Mr. Stengel's attorney at the time, about Mr. Stengel's previous alleged attorney, Robert Wayne Lazaro. Surely you remember the over $20,000 in unemployment fraud. Let's listen.
It's been entered into evidence.
I don't have any notes about unemployment, Mr. Rio, so it's not something that came up before you got in case. It's not something that came up before you got in case. It's not something that came up before you got in case.
Mr. Robert Wayne Lazaro refused Mr. Stengel even call Miss Zaleski a liar. In the appeal to the altered evidence trial, Mr. Lazaro was calling Miss Zaleski a liar, forger, violent person, guilty of altering evidence, you name it. However, in the divorce case, where their frauds and scams were in full swing, he demanded by a written letter, Mr. Stengel not even call Miss Zaleski a liar, or he can't represent him. As you just heard, Mr. Lazaro would not even bring up Miss Zaleski's unemployment fraud, or anything. Mr. Lazaro has his own presentation summary, which includes that entire letter.
Getting there.
Well, there was an interruption by you, Mr. Carney. There was a question. But I am having a hard time understanding why we're spending a lot of time on a financial statement that's been admitted by this witness to be inaccurate. I now have in front of me 4 inaccurate statements. So, I'm not sure what to make of that. I'm not sure what to make of that. I'm not sure what to make of that.
Really? A circuit court judge, and you are not sure what to make of that? Well then, allow me to help you out.
West's Annotated Code of Maryland. Criminal Law. Title 9. Crimes Against Public Administration. Subtitle 5. False Statements. 9-508. False information in filing statement prohibited. In general. B. A person may not file a financing statement, or an amendment to a financing statement, that the person knows contains false information. Fines and penalties. C. 1. A person who violates this section, is guilty of a misdemeanor and on conviction, is subject to a fine not exceeding $500. 2. Each act of filing a financing statement, or an amendment, to a financing statement, is a separate violation.
I'm not sure what to make of that. I'm not sure what to make of that.
Let's see now. 10 months later, this is what you made of that. $179,800 of fraudulent judgments.
Did I hear that right? How much did you say?
$179,800 of fraudulent judgments.
Now that's criminal.
And, if we listen to Judge Kathleen G. Cox, on November the 16th, 2015, we have this.
I'm going to live with the letter of the law. I'm going to live with the letter of the law.
Therefore, Judge Judith Enza is also guilty of... Well, let's see what the law makes of that.
West's Annotated Code of Maryland. Criminal Law. Title 8. Fraud and Related Crimes. Subtitle 6. Counterfeiting and related crimes. 8-602. Issuing counterfeit private instruments and documents. Prohibited. A person, with intent to defraud another, may not issue or publish as true a counterfeit instrument or document listed in 8-601 of this subtitle. Penalty. B. A person who violates this section, is guilty of a felony, and on conviction, is subject to imprisonment not exceeding 10 years, or a fine not exceeding $1,000, or both.
What else did Judge Tisjudicenza know in those regards?
The business income. It's more likely that her actual gross income prior to expenses is more in the range of $169,000 for 2012. In the alternative, Mrs. Stengels indicated on her most recent financial statement, I believe similar to the one that was filed.
Sorry, start over. I was then distracted by Mrs. Stengels. I'm so even.
I'm glad that you're trying to pay attention to what I have to say.
And I don't understand why the people for whom this should matter most want to make it so difficult. Go ahead.
Well, speaking of...
The last I remember was you said she was going to, if it all went prorated, it would be $160,000 a year.
169.
Okay, thanks.
Although it's not all of Miss Zaleski's income, $169,000 divided by 12 equals $14,000 plus per month. Not zero, and not $2,418.
On another note, Mrs. Stengel testified that she accepted a check from Mr. Stengel for the amount of $10,000, which was made out to her father's estate for the purposes of paying off her father's girlfriend, who was...
But that's not really an issue in front of me anymore, is it?
Well, yeah, that has not been resolved.
Oh, yes, it was.
I'm sorry.
Mrs. Stengel said on the witness stand under oath, I'll take care of that. I'm going to pay him.
Well, and I believe that she also said that even though the memo line said that it was clearly a loan, she didn't realize that and didn't know.
Until just now that she's fine with it. She knows she's paying $10,000.
So we have that taken care of.
I believe you do.
After several months, Mr. Stengel filed suit for the $10,000. Mr. Stengel was demanded to drop that case. However, Judge Tisjudicenza, 10 months later, refused to bring the $10,000 down to a judgment, leaving it in limbo. How obvious is Judge Tisjudicenza's insane amount of fraudulent actions, and with the obvious foreknowledge he is a fraud? Let's take just one sample of the bill descriptions used as evidence. It's Mr. Stengel's actions which are driving the litigation. In the Circuit Court for Baltimore County, Consent Order, page number 1.
It is this 22nd day of December, 2010. 5. Ordered that Dr. Kathleen Killy shall conduct a full custody evaluation in this matter. All costs shall be advanced by the plaintiff, subject to reapportionment by the court, and it is further. 6. Ordered that said custody evaluation shall include psychological evaluations of both parties in this matter.
That's pretty clear. Dr. Catherine Killeen, hired on January 7, 2011, for child custody evaluations and psychological evaluations on both parents. Let's take a look at what occurred, smack in the middle of Dr. Killeen's role in the process. Let's also keep in mind, Judge Tisjudicenza not only read the descriptions in the bills, rather studied them.
I went through the bills. I went through them line by line. I studied the descriptions of the work performed.
Dr. Catherine Killeen begins on January 7, 2011. Dr. Catherine Killeen testifies on December 1, 2011, where she states her evaluations ended in September 2011. Let's clear out the areas for what's to come. Mr. Carney's bill notes.
May 31, 2011, research criminal law statutes, other crimes against person, surveillance. Study emails from client for use in petition for contempt, and motion for psychological evaluation.
Note, billed 1.10 hours for $220. Surely that must be an error. After all, that is exactly what Dr. Catherine Killeen is doing, per the consent court order, dated December 22, 2010.
I studied the descriptions of the work performed.
Mr. Carney's bill notes.
May 31, 2011, read through emails to prepare as exhibits, and draft motion for psychological evaluation.
Note, billed 2.80 hours for $560. Again, what's going on here? Surely Enza will see these.
I studied the descriptions of the work performed.
Mr. Carney's bill notes.
June 2, 2011, complete motion for psychological evaluation, with attached exhibits and order.
Note, although billed with other fraud, it's all fraud, therefore, billed 5.10 hours for $1,020.
I studied the descriptions of the work performed.
Mr. Carney's bill notes.
June 15, 2011, revise and sign motion to shorten time and order, motion for payment of private school tuition and order, and motion to refer plaintiff for exam, by court psychiatrist.
Note, Mr. Carney himself is getting into the action, and billed 0.50 hours for $187.50.
I studied the descriptions of the work performed.
Mr. Carney's bill notes.
June 15, 2011, revise motion for psychological evaluation and order.
Note, billed 0.50 hours for $100.
I studied the descriptions of the work performed. I only have the pleadings filed and the descriptions delineated in the bills themselves.
Is that enough? Line items, complete with descriptions, for Judge this Judice Enza. Also obvious is, this is Mr. Carney scams. Exploding like fireworks, on the 4th of July. Now, either Judge this Judice Enza is. Forget that. Judice Enza is a full member of this crime ring. There is one more piece, to further entrench this villain. The order assigning Dr. Killeen to that very task, and by court order, was signed by. And for the cherry on top of this fraud cake, Judice Enza was the judge that also signed that very order. There is always more. Here is just one more, for now. Mr. Carney's bill notes.
July 20, 2011, BGC, Reed L. Bergs, answers to motions to compel tuition payments, and psychiatric evaluation of Mark, and Dr. Killeen's affidavits.
Billed 0.40 hours for $150. Note, it appears Mr. Leon W. Berg is teaming up with Mr. Carney, and provided or discussing Mr. Stengel in regards to psychiatric evaluation. Also noted is Dr. Killeen's affidavits, plural. Dr. Killeen, in the middle of her so-called impartial and independent psychological evaluation, provides affidavits against Mr. Stengel and his children.
I studied the descriptions of the work performed.
We look at the spread the fraud sheet's bills for an overhead view. You will notice neither Leon W. Berg or Dr. Catherine Killeen have anything noted in their columns. If we glance 2 lines up, Mr. Carney's bill notes.
Reed B. Lazzaro's letter of July 15, 2011, to civil assignment, opposing my request to add education motion to July 27, 2011 hearing, call from L. Berg to discuss.
Billed 0.30 hours for $112.50. Note, the amount of criminal conspiracy and collusion in their own bills against Mr. Stengel and his children and their hundreds of victims is astounding. Bills, which they all demand, Mr. Stengel pay. Enza went line by line, agrees with her crime team. Again, you will notice, Mr. Berg's column is, yet again, empty. Mr. Berg is more selective, for which of his crimes he bills for.
I studied the descriptions of the work performed.
Let's add some sprinkles on this fraud cake.
July 22, 2011, 0.60 hours. Create interview outline for Michael Stengel. July 25, 2011, 0.70 hours. Interview with Michael Stengel, notes.
Mark Stengel, plaintiff, versus Susan Siliski Stengel, defendant. Case number 03C10-014265. Affidavit.
I, Michael Stengel, affirm under the penalties of perjury the following information to be true to the best of my knowledge, information, and belief. 1. I am over 18 years of age, and competent to testify with regard to this matter. 2. I am the nephew of plaintiff, Mark Stengel. 3. On or about July 25, 2011, the defendant's attorney, Mr. Bradford Carney, interviewed me for approximately 30 minutes. During this interview, Mr. Carney made allegations regarding a previous mortgage business, which my uncle, Mark Stengel, and I operated, and the reasons for the business closure. Allegations which included my uncle committing criminal activities, which I considered to be strange. I explained to Mr. Carney that was not the case, as the entire industry was in turmoil, as the true reason. However, Mr. Carney continued pressuring me. 4. I began to feel harassed, as Mr. Carney was relentless, and appeared to be determined, to have me agree with his incorrect allegations. It became apparent, Mr. Carney wanted me to testify against my uncle, with his incorrect allegations, rather than the facts surrounding the business closure. Michael Stengel.
I went through the bills. I went through them line by line. I studied the descriptions of the work performed, and I considered the rates charged. Part of that review, frankly, was with an eye to determining who was actually driving the litigation. And of course, for that, I only have the pleadings filed and the descriptions delineated in the bills themselves. I do find the hourly rates charged to be fair. I find the time allotted for the tasks performed reasonable. I find that of the almost $200,000 in legal bills, much is attributable to inappropriate actions on the part of Mr. Stengel.
Bar a tree. N. Creating legal business, by stirring up disputes and quarrels, generally for the benefit of the lawyer, who sees fees in the matter. Bar a tree is illegal, in all states, and subject to criminal punishment, and or discipline by the state bar, but there must be a showing that the resulting lawsuit was totally groundless. There is a lot of borderline bar a tree in which attorneys, in the name of being tough or protecting the client, fail to seek avenues for settlement of disputes, or will not tell the client he or she has no legitimate claim. Mr. Stengel was falsely incarcerated, then forced by the state to complete an extensive psychological evaluation by a psychiatrist chosen by the state. Those results contradicted Dr. Killeen's fraudulent and bogus results. In fact, the report stated Mr. Stengel's complaints regarding attorney and judicial corruption has merit. OK. 11 months after decision day, aka the fraud circus, comes a contempt hearing on August the 27th, 2014. Why? Because there shall be no warning the public or anyone about this crime ring. That's an order. So, we already know Judge this Judith Cienza is furious about videos of actual events. However, she is interested in fraud bills loaded with collusion, conspiracy, and abuses to society. Let's listen to Judge this Judith Cienza in regards to 1. The contempt hearing and their fraudulent gag order. 2. What else Judge this Judith Cienza is not interested in. 3. And finally, you will hear Dr. Enza provide her own expert opinion.
He posted about the divorce, and by that I mean his unhappiness with the expert's opinion, with Mr. Berg's activities, with Mr. Carney. Absent the divorce proceeding, Mr. Berg would have no connection with these children. None. It's only because of the divorce. So his postings arise out of the divorce. He was not to post anything about the divorce, and he chose to do so. Now, there's been this undercurrent this morning about psychological evaluation with respect to a criminal case. I wasn't provided with a copy of that. I'm not asking to see a copy of it. There are no doubt mental health issues involved.
There you go. 1. Enza is demanding crimes continue. 2. Enza is not interested in the state-ordered psych evaluation. Note, obviously, she already knows those results. Therefore, Enza is confessing to ex parte communications. 3. And finally, Dr. Enza has her own conflicting evaluation. Therefore, what was the need for Dr. Catherine Killeen?
There are no doubt mental health issues involved.
Judith Cienza has been warned by the Maryland Commission on Judicial Disabilities, specifically related to her actions relating to Mr. Stengel's cases, plural.
The Commission has more work to do. Judge this Kathleen G. Cox, re-elected via fraud. Surprise! The evil fact, the children were served up to a well-known, violent psychopath, and forced into a world of delusion, along with entire communities continually violated and abused, apparently, are casualties of a divorce. At least we know, that's how all of these, now famous, unconscionable, child and public predators, see it. And, always remember. Let's listen to Judge this Judith Enza pass along a message to Raymond Teamy, appellate judge, who Miss Silisky calls Uncle Ray.
May I ask a housekeeping question, Your Honor? Do you want one comprehensive order that deals with all your rulings today on all the different motions?
Yes.
Or you want separate orders for everything?
No, I don't think so. I think
Okay.
the whole kit and caboodle, because if this is going to the Court of Special Appeals, or if it ends up going to some other judge, I frankly, and I'm not boo-booing about this, I'm not, but I don't want anyone to have to do what I did. I don't. I want someone to be able to look at my decision today and that chronology I gave and the order that you're going to provide to me, and I want them to be able to move forward from those documents.
Okay.
I don't want anyone to have to read these 6 volumes. I don't.
I understand.
We bet you don't. Go on. Tell everyone why. This should explain it.
It's about how people were manipulated and conned against myself and my children. Okay? And to this day, they still don't know. So these people want to leave these people, and there are hundreds of them, in a state of delusion. That's their attempt, to leave them in a state. Don't let the victims know, by the way, that they've been victimized by these people. And we're going to sign an order that you can't tell the victims that they're victims. Okay? And instead, we're gonna brainwash them, and we're gonna make them deluded, where they send me a letter threatening me criminal prosecution should I contact them. Now, I have one question for Your Honor. What would it take for you to sign anything to give away your own First Amendment right to receive information?
Explain it to this group.
Anyone interested in signing on to Team F, Team Carney, Team Silisky, Team Berg, Team Killeen, Team Lazaro, Team Emza, Team Cox, Team Grossman, Team Schellenberger, Team Fab4 and more?
Come on in. This house is stable. We all promise.
I believe it comes with an appellate judge as well.
Don't listen to Mr. Stengel. Come on in. We can explain it all.
Be careful. It's not much different than a child being lowered into a panel van. Exactly how they wrongfully involved so many people and organizations, as they used taxpayer dollars to line their pockets.
Ask Carney and Enza about their Sinners case. Ask Carney and Enza about their Sinners case.
How much is just one memory worth? How much is just one missed memory worth? Highlight title. 2 can play at this game.
So, if we were to just take a few puzzle pieces and put them in order, what's really going on? There are thousands. So, let's just do 3 for now. November the 26th, 2012, Mr. Stengel is illegally cock-blocked by Judge Judith Enza and not permitted to ask questions of the bills he will be demanded to pay.
I have a question for Your Honor, if you don't mind. In relation to Mr. Carney's bills, am I able to ask him questions in regards to his bills? No.
4 days later, on November the 30th, 2012, comes the last day of trial. Mr. Bradford G.Y. Carney, having already been advised 4 days prior by his crime ring member, therefore, now knowing for sure his fraudulent bills are not going to even be questioned, Mr. Bradford G.Y. Carney provides his full-out, on-the-record, confession.
As the court pointed out earlier, it's a whole lot more expensive to lie than it is to tell the truth. Because as Mr. Fetter said, to ferret out the lie, you've got to do more work. And the more work I did, the more frustrating it became because I just kept coming up empty.
September the 18th, 2013. Decision day. 9+ months after Mr. Bradford G.Y. Carney's confession comes the line-by-line lady.
I went through the bills. I went through them line by line. I studied the descriptions of the work performed, and I considered the rates charged. Part of that review, frankly, was with an eye to determining who was actually driving the litigation. And of course, for that, I only have the pleadings filed and the descriptions delineated in the bills themselves. I do find the hourly rates charged to be fair. I find the time allotted for the tasks performed reasonable. I find that of the almost $200,000 in legal bills, much is attributable to inappropriate actions on the part of Mr. Stengel.
Did I hear that right? $200,000 plus of counterfeit orders and fraud bills. And nothing. Zero evidence. If Mr. Carney confessed, his $200,000 of bills resulted in nothing, then all that he wrote in his bills were a complete waste of time, assuming it was all actually done. In which case, when does their counterfeiting orders become obvious? After $10,000 and no results. After $25,000. After $50,000. Mr. Carney is confessing of committing many crimes. Very serious crimes. Leaving only one question. How could Judith Enza, over 9 months later, use those very line items as weapons against Mr. Stengel?
There is but one answer to the question.
How could Judith Enza, over 9 months later, use those very line items as weapons against Mr. Stengel? Please tell.
The how part is exactly what creates, or is in some way connected to, most of the problems that exist. How Judge Judith Enza can navigate that is derived from being an extremely high-level unconscionable. They don't follow rules or laws. They make the stuff up. Constantly. Just like she made that up, right in the face of a confession to the contrary, and in open court. In her own courtroom. These are the dangerous people in society. They commit numerous crimes to retain their judicial position on the bench, as Judge this Kathleen G. Cox did in November 2016. How is Kathleen Cox still carrying that very torch, and refusing to let it go, and recuse herself? In fact, she has committed and assisted in more crimes over multiple years than one can possibly imagine. How? The alienation game. Sound familiar? Sound familiar? Or, you can watch and listen to another research subject, Donald Trump. Remove the backgrounds, and their actions are often similar. Lie. Keep lying. It's never their fault. Chaos surrounds them. They always have witnesses. Because, isn't it every day, you need a witness for something? Also a confession, one's word, is not valid on its own. As such, they require a witness, or witnesses. There you go. The descriptions in the bills. And the pleadings. aka, all the intentional, falsely, sworn to stuff, including confessions of criminal acts. You mix them together, and you have fraud stew. Made from the same wholesome ingredients, as found in the foundation built on November 29, 2010, Ms. Zaleski's first fraudulent protective order. And this fraud stew contains nothing but more fraud on top of the many fraud layers upon layers piled upon that very foundation, as they all collectively printed their counterfeit orders, or authorized and approved of those counterfeit orders, while building their house of fraud.
Justice. A judge abides by facts, laws, truths and evidence. A justice creates their own facts, laws and truths, in the face of opposing evidence, and, or knowingly apply lies to law. When the scales of justice become the scales of injustice. Note, this ad has been authorized by the actions of the Judgetis. Judgetis Judith C. Enza. Note, the knighting of a Judgetis is taken very seriously. Similar to the Supreme Court, it's for life. Important, this term was specifically designed to separate the honorable judges from the dishonorable ones.
Now, let's revisit the intentional, illegal, and fraudulent act on November 26, 2012.
I have a question for Your Honor, if you don't mind. In relation to Mr. Carney's bills, am I able to ask him questions in regards to his bills?
No.
No?
Forgetting that, it's hundreds of thousands of dollars. Even if it was $500. Or $50. You can't ask questions. What psychotic planet does this whack job live on? Dear Judge, this Enza's auto mechanic, the next time she brings her vehicle in for a tune-up, or for whatever, the whatever is irrelevant, as long as it's noted on the bill. Go on, and list all kinds of things. You put an engine in, new transmission, even an oil change. You must have done that before you change the engine, tires, a radiator, and anything you can think of. No, don't actually do the work. Just note it on the bill. And do not complete the work she did come in for, such as the tune-up. Have you ever heard of extremes? That's how they do it. When she comes in, just hand her the bill. What is it? $9,124.76. Now, there is one rule, which she is very familiar with. She can't ask you any questions. Got it? No, do not do this to anyone else, ever. That would be a criminal act, called counterfeiting orders. However, this is specially assigned to Judge this Judith Enza. One last thing. Tell her Mr. Stengel says hello, and if this one segment doesn't tell her how out of her psychotic league she really is, she is even further out. Way out. Before I go, do you happen to know where she buys clothes, or restaurants she frequents? I would like to speak with them as well. Yes, it's all part of the specially assigned concept.
Can't wait till you end up in prison. Can't wait till you end up in prison.
Witnesses. 1. Alexander Stengel. 2. Maya Stengel. Witnesses. 1. Alexander Stengel. 2. Maya Stengel. Witnesses. 1. Alexander Stengel. 2. Maya Stengel. Witnesses. 1. Alexander Stengel. 2. Maya Stengel.
Day December 18th. The day I finally broke out of prison. It's August 26th at 9 a.m. and if anyone hears this, I just want to stay with my dad. By that I mean like full custody with my dad.
Insert disc number 6. Go on.